For the foregoing reasons, impugned judgment dated 14/2/2025 is quashed and set aside. The respondent shall include in the merit list those appellants who have secured more marks than the last selected candidate in the general category. Interlocutory applications are allowed. In the result, appeals are allowed. There shall be no order as to costs. Yeah. Yes.
My lords, I'm requesting for listing of IA for stay. The urgency is your lordships had issued notice on the... my lords, first is showing as registrar court date. May I then request for 6th to 9th?
Okay, take 6th to come.
Obliged, my lord.
Next.
My lords, this matter was listed on 19th, but it could not be taken up. Say MBBS student, my lords.
If it is 19th, put it up or else some other day. Next.
Obliged.
24th,
24th.
not to be deleted.
Wait.
1st of April, not to be deleted.
My lords,
804, yes.
counter affidavit.
You are there?
My lords, may I mention
My
item
lords,
27?
it's an oral mentioning, I beg, my lords. My seeking permission to file counter affidavits, your lordship.
My lords, may I
Obliged.
mention item 27 listed
When
tomorrow?
is that matter coming? When is the matter coming?
It is showing on 6th of April, your lordships.
My lords, I'm mentioning my item 27 listed tomorrow on behalf of respondent number 1. The counsel for respondent number 1 is in some personal difficulty.
Circulate a letter.
All right, my lords. Actually, if we have informed the other.
Circulate a letter. Why are you mentioning?
Certainly, my lords.
Item 1.
Right.
Lordship, may I have Lordship's liberty to mention? May I have Lordship's liberty to mention item 18 of tomorrow? Lordship, my father is unwell. I am circulating a letter just to have a convenience.
What is it?
Doesn't
What is he mentioning? We can't hear him.
Your lordship, tomorrow item 18 is listed.
Item 18.
His father is not well. He has to travel. So
All right.
we have already circulated a letter, but
Okay, Kunal is mentioning.
Yes,
Okay,
yes.
all right, Kunal, we'll accommodate.
Yes, Lordship.
we have already circulated a letter.
Fine.
Just mentioning for your comment.
Take your lordship's permission to make an unlisted mentioning. We are jointly making a request, your lordships. There was a batch matter listed on the 16th before your lordships. This was a RERA matter, if your lordships recall. There was an accommodation, a Passover sought by the other side, and your lordships had adjourned the matter. We are on caveat in some of the SLPs which were listed. Now, when the order came out, we discovered that your lordships have passed an order which says issue notice and status quo. But in fact, on that date, no such order was passed. So there's been some inadvertent error, your lordships.
We don't want to be remembered. We might have issued. Anyway, you are there. It will anyway come down. Doesn't matter. Your window to get the matter dismissed is open wide. Don't worry. You are anyway there. We will hear you and pass. We will expedite it. When is it listed for?
13th.
13th of April. Is it all right? 13th of April is good enough. Because we have too many dates in between. 13th April not to be deleted.
Very well.
We'll remember that.
Very well.
Sir, seeking regular bail.
May I please?
Before
Who is for the state?
I appear for the state, my lords, in this. I appear virtually.
What
My
are
lords, if
main accused?
sorry, my lords.
Main accused inside.
My lords, as per my instructions, yes, my lords, there are certain documents which have been filed by them. I'm so sorry, my lords. Yes.
What do you say about the document? You want to verify?
My lords, that document verification was done, my lords, when they had said that his wife is unwell. That IA got dismissed, if my lords may recall. And my lords had kept this matter for.
Yeah, this for.
Sir, I'm praying for the basically regular bail, that part of the interim bail. So that at that particular point of time,
Taken
Plus,
instruction.
trial is going on at a decent pace, my lords. Now he was absconding. He was caught from the airport, my lords, but while trying to flee to Dubai. My lords, it's not as simple as what they're portraying it, my lords, that way.
3 years have gone by. The trial has commenced, is it?
Yes, my lord, trial has commenced. Around 18 witnesses have been examined as well.
How many accused are there?
My lords, total accused, as per my lords, FIR and charge sheet, one is absconding and still absconding, my lords, and 3 more, my lords, as per my instructions.
No, sir. No, sir. Let me submit, sir. There are 6 accused, sir, who are facing.
Yourself for trying to abscond.
No, no, sir. No, no, sir. Sir, I am in custody since 2 years, 7 months.
Case.
Sir, second aspect
Not
is.
to matter.
No, no, sir. Second aspect is, sir, kindly see an extra
Murdered.
plate. Sir, kindly, sir, hear me on merit, sir. Just for a.
Can we hear you on merits? It's a bail matter.
Yes, sir. Sir, kindly, sir, there are 5 challans have been submitted before the trial court. In total, there are 227 witnesses. If I cut down the repetition witnesses, then there are 88 witnesses are there. Then thereafter, sir, kindly, only 18 witnesses has been examined till date,
We
sir.
are not on the propensity.
Sir, secondly,
we are on the propensity.
Co-accused bail accepted by this honorable court, sir.
Sorry?
Sir, co-accused bail Mohammed Shakib Dar is accepted by this honorable court, though I have a lesser, as per the allegation, lesser offences. The person who has got the bail from this honorable court,
But
sir, he has
There was no occasion of.
only 4 points, sir. Sir, only please kindly, sir, hear me on.
Not listening to what doubts
sir,
the court has. We are
sir,
not
just give me.
against grant of bail, but we are
No, no, sir.
to you the problem.
No, sir, kindly hear me, sir. Only 4, I just want to correlate the 4 things, sir. One is Mohammed Shakib Dar, who has granted the bail by this honorable court. He has transported the accused. He has financed the crime. He has conspirator. He was a conspirator at the initial stage. Thereafter, he is harboring the accused, sir. So far as related to mine, sir, only disclosure statements are there, which are merely a confessional statement. No recovery has been effected from the petitioner, sir. And so far as related to disclosure statements, those are different, sir. I filed a chart, comparative chart on 7th January, sir. Have a look on that, sir. I can easily, sir, argue on that particular point. So far as related to flight risks, sir, which are the state is saying.
What do you say about that?
Sir, kindly see P5, annexure P5. P58 is, page number 58 is relevant. I have booked my return ticket. My visa for Dubai was valid till 2nd of October. But I have booked my ticket on after 5 days, sir. Return ticket was my return ticket was already on record, and this is a relied upon document of the state, sir.
He was a PO.
Sir.
The 1st August, he was declared PO. 6th,
My
he
lords,
was going to Mumbai when he was.
Nikhil, say if I may, please.
Sir, petitioner wanted to start his
My
business of the
My
public.
lords,
Are you finished?
Sir,
Or you want
the
to-
alleged crime is of 2021 for
One
good 2
minute,
years.
don't interrupt.
Sir, kindly have a look on 58 page number, sir. This is my return ticket.
Return by itself is not.
Sir, visa is or till the 2nd. If I had I any kind of intention to not returning back to the India, sir, my wife is there, my small minor daughter is there, sir, in India. So I have no chance to abscond from the penal.
Where are you going? On?
Sorry, sir.
What have you got to do to go abroad? What reason?
Sir, reason for going to Dubai, I wanted to start my.
What? When a criminal case,
Sir, I'm not
suspicious. It's not as if you stay there. All of a sudden you think of your one fellow ran away, one accused ran away, and following suit you are about to go. It's not as if you are doing a business there or your family is there. Nothing at all. There is no reason for you to go abroad.
No, sir. Actually, petitioner wanted to
It's a
start
holiday.
his business of perfumes because he was residing in at that particular point of in Bombay. There was a
Why?
sir.
Why was he going?
Sir, because of the earlier he also resided at the Gujarat for the driving purpose, sir.
Why was he going abroad?
Sir, for this because of the sir Dubai, he went to Dubai only because of to establish his business for the because he wanted to call the containers at the Dubai airport, sir.
Not for the present, no.
Sir, kindly have a look on.
We have heard you. I don't have enough complaint. We have heard you. Not for the present. Just let the trial. While we are not inclined to interfere with while we are not inclined
Sir,
to entertain the petition for the present, the petitioner is given liberty to move an application for grant of bail after examination of some of the crucial witnesses is completed. We have kept it open-ended for you.
Grateful, Lordship.
I want to
Come
submit
back
one
on.
more thing,
Grateful,
sir,
Your
if your lordship permit.
Yes.
Out of 18 witnesses, 88 witnesses are of the eyewitness, not even a single witness, even 18 witnesses has not named the
Wait,
petitioner, sir.
Please, that
Not even a single.
right issue is over.
Grateful, Lordship.
Next.
Sir, kindly fix it for that in a time-bound manner, sir.
No, we are disposing of. Where is the question? You can move again. Next.
May I please, my lords? Lords, Rayat Wari Patta has been granted in my favor, my lords. The main intention of granting the Rayat Wari Patta is to confer title to the peasants, my lords. And the respondents are,
Right.
my lords, yes, my lord.
It's a inam, it's a service inam.
No, my lords, it's a personal grant. My lords, that's the issue.
Even worse.
My lords, kindly see page.
It was.
My lords, kindly see page number 68, my lords. That is the settlement officers.
Frequent purchase. There is a question.
My lords, even my lords, the respondent stand is, my lords, they come under HR&C, my lords. My lords, if at all, even that is assumed, my lords, the trial courts doesn't have any jurisdiction, my lords. My lords,
Temple lands like this to right, left, and center.
my lords, it's a personal grant, my lords. My lords, kindly see page number 68, my lords.
Tell us, what is this? You're coming after 1,061 days?
My lords, there is a change of advocate, my lords. There is some miscommunication, my lords. Kindly, that may be considered, my lord, for the sake of the merits, my lord. My lords, the civil court doesn't have jurisdiction, my lords. My lords, they have to do proceedings as per 78, 79 of HR&C Act, my lords.
Temple lands.
My lords, they are telling that there is a condition violation, my lords. Even it is affected by 34B of the HR&C Act, my lords. The civil court doesn't have jurisdiction, my lords. And that too, this suit is for possession, my lords, not for the title.
Thank you. Dismissed. Next.
Right.
An appellant in person, restoration application has been moved.
How many times you move the same?
Lordship, with
Next week, Lara. Next Monday. Next week. We'll just disclose it up next time. Person.
But there's a letter in item 4.
item 5.
Please suit for damages.
Lordship, it's a case of reversal by the High Court in first appeal. I was granted the lease of the property in 1980 for 20 years. In 1986-97, suddenly the respondent comes and builds a road. Because of that, two parts are divided.
The evidence nahi hai,
The only
damages.
problem with you is that courts have found that there is no evidence and culverts which were existing. So therefore, when you didn't produce any evidence for damages,
No, I produced. That is what the trial court said.
these are fact. How do we interfere? They are saying there is no evidence. We have also seen what's the evidence. The culverts that you said are already existing.
Yes.
So first appeal findings of fact of the first appellate court. What is there for us to interfere? Thank you.
Lordship, the trial court, if I may just point
Six
out to your
items.
lordships, there is a judgment of your lordships on a similar line. A similar thing happened. If your lordships may kindly allow me to
Depends on facts.
press into service, my lords.
Depends on facts.
No, lordships, why your lordships in a similar case, when there was a dam constructed and there was also a salt manufacturing unit, your lordship said that even if most of the precautions are taken, then also there are damages which have to be paid. The trial court has not granted me the entire claim. The trial court said that
Your
since
claim itself is how many?
What is the basis for granting even 1/3? That's the
Lordship,
problem.
that is what the
The
case
first
report.
appellate court says that it is based on surmises and conjectures. What is the evidence which you have?
No,
led?
that if your lordships may kindly
There's
have
no
a look
evidence.
at the audit report, which I produced, no one disputed.
Findings.
The trial court has,
Total
lordship,
findings of fact.
trial court had held in my favor.
Thank
The
you.
first appellate court has reversed.
That's the last quote on facts. Thank you. Dismiss.
My lords, obliged.
Interim orders.
Please, my lord.
Condoning delay. What?
Malas, in this matter, Malas, first appeal was decided, Malas, on the 6th of.
Known the delay and restored second appeal. Why will we interfere? Second appeal is restored, right?
Yes, Malas.
Admitted the second appeal and condoned the short delay. How do we?
Malas, there is a delay of 284 days, Malas. There is no reason explained for the, Malas,
We
delay.
contest it on merits. It doesn't matter. Dismissed. Next.
Item 7.
Please.
There was a delay.
We condone the delay.
Item 7.
Liquidator. Passover.
My lord, in item number 7, my lordship, the matter was dismissed in default by the complete law tribunal. I preferred a appeal. There is appeal was within time, but in curing the defect, the delay occurred, my lordship. Without the condoning delay, my lordship, it was again dismissed, my lordship. My substantial right is involved, my lordship.
24 days delay in an IBC matter, its whole purpose is lost if you.
My lords, if the main matter is, I am instructed to say many litigations are pending. It is not that the only litigation, my lordship.
NCLT, normally they come there.
My lordship,
The move, you are only a liquidator.
no, my lordship, it's a, I am from the official liquidator, my lordship, and I am challenging the preferential and undervalued and fraudulent transactions, my lordship. In that time, my lordship, the whole cause will be defeated, my lordship. My lordship, kindly, if you notice, at least find out. And my lordship, technical grounds only, my lords, my advocates.
Notice.
Highly obliged, my lordship.
Please, madam.
Well, the office report says that the wakalatnama is not signed by the respondent.
We'll wait for some time. What do you want us to do? Or we'll
Some
issue
time may be
notice.
given, Malad, so that I may also look into the affidavit which they have.
We'll issue notice. Personal presence is exempt.
Grateful, Malad.
Lord, I am a charitable trust running a school. No profit means. I move a modification. My modification is allowed, but it's not recorded in the order. All I want is a bank guarantee, nothing else, my lord. Just in a form of bank guarantee, because 130 is a lot for me, 1.3 crores.
But then trial, they gave you 50% to deposit. Even that if you can't do, then what's the point in people?
My lord, I'm not pressing on 50%. Now, whatever has been awarded, I'll bow down. It is only in form of bank guarantee, my lord.
Interim order.
It's a big amount. I'm already down with 15 crore loan, my lord.
Trust, is it? Construction of a road.
I've already taken 15 crores loan. I've put my balance sheet also. It's a charitable trust running a school, my lord. No profit means. From 180, it's gone down to 130. I'm grateful for that, my lord. It is just a bank guarantee I'll be able to furnish, my lord.
There's no end to this if we say that.
My lord, I'll really bow down if.
Notice.
Obliged.
Please, Mulats. Please, Mulats. Here the High Court in a second appeal affirms it.
Lord,
There's already an of execution.
There's already an order passed by a lordship dismissing the SLP with impugned judgment.
Their SLP has got dismissed. When they challenge,
That got oh, you filed an SLP, your SLP is dismissed.
their SLP is dismissed. But, my lord, as far as
But you bought it for how long? Now that you are there, you tell us 70 times. It's okay. Now that you're there, only thing is that there's no reasons.
Not only no
Except
reasons,
that
it's
the-
an income.
except that the value is increased phenomenally, which is true. Nobody doubts about that. fact.
according to us, it's still a
70 times
throw.
consideration. But
According to us, it's still a
dragged on.
And I have paid the consideration.
3
I've already, I'm sorry.
Lost 3 acres of land at 1 crore at 17 lakhs. Rate in that area
1 crore,
is working the road.
92 lakhs, no?
Please, my lord. As per the agreement dated 1990.
No, 1 crore, it turns out how much? Now it has worked out to 1.17 crores, is it? 1.1
17 lakhs. 1 crore 17 lakhs.
Please, Malats.
So you say a round figure, Mr. Hegde.
Malaj, they haven't deposited that also, Malaj. Honorable High Court has given them 3 months time to deposit.
I'm sorry, my lord.
Okay, no, there's no need for any arguments on this. So,
no,
some kind of a figure
My lord,
can settle and
what I wish to say is this, Malaj. Malaj have already dismissed one SLP with impugned judgment, Malaj.
That is your SLP, sir, not his
Still,
SLP.
Malaj, the dismissal
What is that?
them also.
50-50.
But there is no basis for that.
Malaj, as
You
per
take
the
instruction.
judge bench in TK David, Malaj, it says when the main judgment cannot be interfered with, Malaj.
But he should.
Take instructions, issue notice.
My lords, let's split the difference and finish it.
That's what we are saying.
According to us, Malaj, it's ekada crore, Malaj.
50 lakhs to pay. That should be, matter should be ending, 50 lakhs.
50 lakhs minus what has been deposited and whatever is there to the credit of the suit, that give me
Take
credit.
instruction. Issue notice, so and so takes notice on behalf of the respondent. Pending disposal of the special petition, there shall be a stay of execution.
Obliged.
Grateful.
Issue notice
So may I-
confined to, issue
will-
notice confined to question of settlement between the parties pending disposal.
And a returnable date. And a returnable date, that, because otherwise then this will linger and then it will go.
We'll always give a date.
Obliged.
Item 11.
SEBI order is a well-reasoned speaking order. The SAT reverses despite the fact that the provision contains a deeming provision.
If his own family members.
My lord, finding of fact that when the party had.
No, it's a finding of fact, but then own family members are a little more.
Under the regulations,
bit too more liberal.
Not the compliance officer under the regulation.
Regulator must
discretion
have
to
the
decide.
jurisdiction to say that he can't even.
But
We are not about this case, we might even close your case. The approach adopted is a little, causes difficulty to a regulator.
No, just para 17, my lord, your lordship, just consider para 17. There are three limbs on which the conclusion rests. It's not only on one aspect as if the compliance officer's discretion is final. The finding of fact is, Lord, please read para 17. Lord. In our opinion, in this case, the purchase of shares by the appellants cannot be construed in the UPSI period. We say so because firstly, there is no material on record to come to a definite conclusion that MIS reports were shared with the appellants. This is a finding of fact, my lord. On the other hand, the specific answer given by company to question number 6 is that no information was shared with the promoters during the quarter ended September 30th, 2017. Secondly, prior to the amendment, the discretion to decide the UPSI period and closure of the window vested with the compliance officer, and he has fixed the date as on 4th November 2017. It is relevant to note that no action.
It is admitted that the management shared the
Page 10
management information with all the senior managers.
But when
And
was
following that information, they set up.
when was it shared is the moot question, my lord. When was it shared is the moot question. That
Just before the IPO.
It was shared on 3rd November. That's why the compliance officer fixes 4th.
3rd November?
3rd November 2017. The trades are all in October 2017. Please just see the.
Closer, it's even more.
Lord,
It's
because under
obvious, isn't it?
Lord, what has happened is, Lord, let me just take
He himself is so.
10 seconds, my lord, 10 seconds. The trades are on 26th October.
26th October.
Of 2017.
No, between November 27, right?
No,
November 2017.
The exit.
IPO, okay. What you're saying is it's post IPO is what you're saying.
It is post IPO. The UPSI period is the moot question. When did that price sensitive information come into existence? SEBI's case is it's 3rd October 2017. Our case is it's 4th November 2017. Why are they getting this 3rd October from? Because the law was amended in 2018 with effect from 2019 to say, shut the trading window from the end of the quarter till 48 hours results are declared. Now, that was not the law at the relevant time. At the relevant time, the compliance officer had the discretion to decide when to fix the trading window. And they have not acted against
Will not do it so strictly. They have a duty to ensure that the market doesn't get disturbed. Normally, we misunderstand SEBI's role. They have an ex ante power.
I quite see that.
Ex ante power in the sense that they will have to take a measure before the damage occurs. So, anyway, take notice.
Please, Your Lordship. My Lordship may stay the order because the amount is lying with the SAT, my lords. Amount we are not taking back.
Need for stay.
Restraint
We
to.
issue notice, we are considering the question of law.
Very well.
We will not stay there.
Very well.
Very well.
They are absolutely notice.
Grateful, my lords. You must do.
Obliged, deeply.
Please, my. The finding on the second appeal, the Honorable High Court again confirms paragraph 21-22. The real question is whether the sale consideration was paid or not. The trial court decided in my favor. Admittedly, two of the defendants admitted on page 170. The trial court records. Now, may I submit, my lord? The question is to correlation between section 43 of the Transfer Property Act, section 58 of the Evidence Act. Now, the question, what has been? Please.
The finding is that you have played fraud to get the sale deed executed on the false pretext of a settlement. That is the finding recorded by the trial court as well as by in the second appeal. And you did not examine your most important witness.
Grateful.
To rebut the claim of the defendant that entire consideration was paid.
I'm grateful for this, my lord. Number one, the finding of the trial court is in my favor. I am the plaintiff. I am agreed by the fake, the SLP, which the sale deed which was executed on the pretext of the settlement. So to that extent, what is coming from the my lord is in my favor, that the trial court has confirmed in my favor. It is against the defendant. The second question comes. The second question that I have not examined. The second question is to be answered in this way. Who has been not examined? The Bhogoi has been not examined, whereas the Surendra Srivastava, the defendant number one, the main person was not examined. Therefore, the non-examination.
All findings.
My lord, may I three things may I submit, my lord, only purely on question of law. I will not go on any other thing. The non-examination, the document, now kindly see the page 170 for a minute, trial court, which is in my favor. High Court and the Honorable Court, the First Appellate Court, have not upset that finding. The First Appellate Court goes on Section 43 of the Transfer Property Act. Of that finding, and the trial court judgment was partially decreed. So that finding is not disturbed. Now, any evidence that the consideration is paid, it has not come on record.
The questions you raised in review also.
My lord, question, therefore,
reiterated that.
I'm not asking, limited part. The review court decides without even at the stage of the notice, without framing question of law, simply confirms.
Review, they should frame question of law.
Now, my lord,
you said that in review they should frame question of law.
Not review, the second appeal. Not review, the second appeal. It is a review in second appeal. Error apparent. And the examination is very narrow, only to the extent of error apparent on the face of the record, which I am going to point out.
Okay, Mr. Sharma. Thank you.
Now, may I point out, my lord, two things. One,
that's enough.
One last thing.
Thank you.
Kindly see, my lord, if 150, they are poor persons, 150 members are there, they are cultivators. I am in possession of the property. Possession was never handed over.
Same point, Mr. Sharma.
No, I'm not.
Thank you.
In the light of Section 30.
Now leave it at that. Thank you.
My lord, may I submit three things?
Item 30.
My lord, may I submit three things? These proceedings, revenue proceedings are pending between the parties. These proceedings will not affect other proceedings.
That's good. Good for you.
So that is only.
Item 30.
Only to that extent, my lord, what I.
That's okay. If it will have independent, it will have it.
My lord, the core question is the true judgment of this court. Section 31, when a person is possession for cancellation of the sale deed.
No, leave it at
that. I will certainly.
Leave it at that.
But I won't go. But the question will remain to be decided by this court.
To contest your
Section
case before the
31
Revenue
and
Authority.
43 of the TP Act.
Right,
Anyway, I can try this much. Grateful, my lord.
May it please the Lordship.
It is a concurrent finding. Maybe.
This is an admitted case that petitioner were minors, at the time when the sale was made, by the mother.
Okay.
May I point out,
Mother herself, it's an evidence to say that she sold the property. Typical case.
May I point out, she purchased the land in the year 1989, and not in 1995. I have raised this.
She has actually sold the property for the family's sake. She bought a better property, better land in 95. After you become majors, all of you.
May I respectfully submit,
A transaction which occurred so back in 90s.
May I respectfully submit, the land was purchased in the year 1989, not in the year 1995 from the sale proceeds. The issue number 2 has wrongly been decided, and I have raised this point, in my first appeal at page number 123. If your lordship may kindly have, this point has not been decided, In fact, I also filed an application under Order 41, Rule 27, That application was also not decided.
Legal people would have purchased property long back, 2000, sold it multiple times. And suddenly you come up and say that my mother could not have sold me. And concurrent findings of both the courts.
With respect, but it was not for the benefit of the minors. And
Thank you.
Obliged, Lords.
My lords, in this matter, my lords, I'm sitting on this suit property from 1995, my lords.
591 days delay, why, sir?
Please, my lords.
591 days, 600 days delay.
Yes, my lords. My lords, I was obtaining the documents and that's why.
And that can't be a ground.
My lords may hear me on merits, my lords.
Dismissed on the ground that it's vexatious.
711 only.
711.
My lords, there is,
Contested
my lords
suit.
may hear me just on 3 grounds.
Tell us. 711, you have to tell us about your delay of 600 days. And that too in a 711 petition. Concurrently, both the courts have dismissed.
My lords, I was collecting the
in the
documents.
meanwhile, suit would have proceeded further. What is it?
My lords, I was collecting the documents and all.
711 can't be commenced. Thank you. Dismissed.
My lords may kindly hear me on merits, my lords.
Sorry?
Kindly hear me on merits, my lords. Just one point.
What is the point? Tell us.
My lords, the point is, I am sitting over the suit property from since 1995, and the title deed on the basis of which this suit has been registered is a forged document. Because, my lords, in the year 1959, this village area where the suit property is located is a colony area, which falls under the Rajasthan Colonization Act. So, my lords, my submission is the Gram Panchayat which issued the title deed did not had the jurisdiction to issue the title deed. The jurisdiction was with Mandi Development Committee, which was a statutory body constituted under the Rajasthan Colonization.
711 petition. After 2 years of concurrent dismissal, not a case. Thank you. Dismissed. Next.
My second appeal was dismissed by the Honorable High Court.
Against trial court, appellate court, second.
My second appeal was dismissed.
Not only second appeal.
Yes, my lord.
What yes?
There is a substantial question of law, my lord. The counterclaim for title
All
was
the
allowed by the
courts have dismissed only on the question of whether you are in possession or not. How?
No, my lord. No, my lord. The counterclaim for title was allowed.
Concurrently. Anyway, not a case for dismissed. Next.
My lord, let me point out, my lord, something, my lord.
Is that
At page number 50.
Formulate a question of law and argue.
Yes, my lord. I am on it, my lord. The Honorable High Court has taken an adverse inference from the suggestion given by the counsel for the plaintiff to the defendant witness about the partition, my lord.
Anyway, Mr. Hari, thank you. Dismissed. Next. Call the next case.
Lordships, I appear for the respondent in this matter. I am under instructions to make a
Yes,
put in my
similar
appearance
matters are there.
and file my wakalatnama, which I will be receiving.
May I only pass on the order, man?
Inflator. Huge batches have now occurred now.
But it's only 4 matters
On
at the
this issue.
moment. 4 matters are there. But may I only request, my lords, that the similar order, your lordships have stayed the impugned judgment. My lords may consider staying the judgment.
Yeah, then stay. You file a counter?
I wish to file my counter.
Same.
File wakalatnama and counter.
Very grateful.
Can I?
Item 17.
Lordship, 4 weeks?
Lord, in a suit filed by me in 2012, after a period of 14 years, that is in 2024, when my evidence was, plaintiff's evidence was totally over, one of the witness of defendant was also examined, an application has been moved under order 16 rule 6.
Applications. Interlocutory applications. Production of
Yes, my lord. So,
signature.
no, but what stage, my lord, it is to be given, and the trial court. No,
You're not joining issue on
no
decision made by the court whether it is right or wrong.
No,
but pending suit, if the courts have passed some interim orders about signature to be.
No, trial court has rejected their application by passing a very well reasoned order. Mala, kindly see the reasoning given by the trial court. Mala, the High Court has not dealt
What
with
is
it.
the High Court for?
High Court says such an application can be filed at any stage. It is not so. Kindly see page 157, the reasoning assigned by the trial court.
Only discretionary order.
No, not only discretionary, but my lord, there has to be pleading. My lord, there is no pleading in respect of the documents which is sought to be, my lord, brought on record. And during entire evidence of plaintiff, I was not there. There is no pleading. I was not confronted. So just see.
The High Court expedite the hearing.
Yes.
No.
Because the High Court has said finish the trial in 9 months because it's a very old.
No, only one, my lord. Just see
Because they
the.
filed the suit 7 years later.
Kindly see, my lord. The
Positives, they have,
No.
councils will have a problem if they.
No, no, I have never been confronted with these documents. My lord, I don't have now. My evidence is over. Kindly see page 157, the reasoning assigned by the trial court. My lord, it's a very well reasoned judgment. My lord, set aside by the High Court, my lord, under revisional jurisdiction. Kindly see page 157.
Yeah, but he will have an opportunity to adduce.
Finding about the finality or the proof of the documents, it's only an admission. So
My lord, it's a settled law, my lord, settled law, my lord. I should be aware, my lord, as I said, there is no pleading in respect of these documents in their written statement. My lord, when my evidence was there, I was not, my lord, kindly see, my lord, the reasoning assigned by the trial court has rejected their application. My lord, kindly see 157, my lord, just a few lines from, at page 157. Page 157, 9th line from the top, your lordship may kindly see. 157.
नहीं करेंगे तो 4127 लगाएगा रिमांड होगा
only few lines I will read.
If they don't do this, it will go in a second and third round. High Court against the final order will go to remand the matter back.
But my lord, how can I, my lord, there is my evidence is over. That's the problem. Kindly see, my lord, reasoning assigned by the trial court.
We will clarify that. You can lead evidence that we can clarify that you will be granted the liberty to lead evidence in rebuttal. But whatever
it is required.
After all, it's only an opinion of an expert. It's a piece of evidence. That's all. Nothing beyond that.
No, my lord. At what stage? Only one, my lord. Few lines.
The High Court, the petitioner will be entitled to lead rebuttal evidence as against the documents, as against the. What happened? Did the reports have the reports got filed or not?
No, my lord, that application has been allowed. Now it will be done.
Evidence, if need be.
Your lordship,
this clarification, especially to
your lordship can consider saying he can make an application for rebuttal evidence. Rather than saying he will be entitled to.
On making.
Which the trial court will consider.
Under the act.
Which the trial court will consider.
Yes, naturally.
No, my lord, because the way the first part is phrased, it's as if it's a direction that he will be entitled.
Has to
your
be
lordship may say.
Because of the reason, because of the reason, petition will be entitled to. Next.
So
but we'll keep it open-ended for you.
Item 18.
Are there similar matters in this?
But in item 18, similar matter has also been dismissed.
They will dismiss, that's what we remember.
Yes. 24.
Correct?
Has been
Okay. Because Mr. Mukesh Verma submits that similar specialty petitions have been discussed when he wrote his statement. I said these times dismissed. There's a huge delay also. 19.
May it please. There's only one request in para 8. Admittedly, my lords, we have not passed the draft order and we should have done it. And my lords, so the assessment order definitely requires to be quashed. But my lords, without a liberty, my lords, given by your lordships to initiate the process, our assessment orders will be barred by limitation. Only request is if your lordships may consider directing us to pass the draft order.
No, Mr. Dismissed.
Otherwise, we'll be forced to accept the return, my lords. Otherwise,
you
it's
should
only
learn. You should learn.
We should, my lords.
Income tax department must learn what to follow the rule.
As it is.
Not just pass orders like that.
Very good.
Item 20.
Item 20, my lords, it's a pure question of law. Where there is no limitation period that is prescribed in the statutes, whether we have the power under 119 to prescribe.
The statute doesn't provide any limitation. How can CBDT provide?
So the statute is silent.
Yes.
119 clothes us with substantial powers. Does it extend to this is the question.
All right. Right.
Obligement. I'm sorry, there is a delay of 264 days.
Notice on delay?
I'm obliged.
In Assam, the Registration Act was also amended 21A. Registration of sale deed requires the NOC from the Deputy Commissioner.
What is this 1351 days?
Yes.
My lord, because review was pending for. For 3 years, the review was pending, my lord. And the review order is January of this year, my lord. That your lordship will find at page 8, 6/1/26. Status quo was operating in the review, my lord. My lord, I just want to show your lordship 2 pages in their own case. If your lordship just have a look at page 171.
Permissions, yes, what?
This, they say that they took the response. Your lordship may just have a look at 1671.
The unfair litigation that you are.
No, your lordship, I'll just show your lordship 2 pages. I'll leave it at that, my lord. There is a point here. If your lordship just,
Totally untenable.
just your lordship may see
What's the
171.
point you're making?
Point is, my lord, this no objection certificate from the deputy commissioner is a prerequisite. There was difficulty in obtaining that. The plaintiff's husband took the responsibility, and your lordship would just have a look at page 171. This is the plaintiff's evidence in the cross. It starts at 170 at 171.
The stands taken by you are very funny.
No, your lordship just have a look at 171, my lord. My lord has 171.
Yeah, yeah.
Second line, my husband was entrusted to obtain the sale permission. My husband submitted the application for sale permission. Sale permission was not issued. Without sale permission, registration cannot be done. Permission was not issued as DAG number of the land did not match. Now, if the husband's also, if your lordship sees, at 189.
Every possible step to
This, your lordship
you
would
have
see,
taken.
324 is the statute, my lord. The 324, your lordship would see. This was a point taken in the review. At 324, 21A, my lord, of the Registration Act. 324, my lord, 21A. Be quoted, my lord. Lordship has 21A at page 324.
All right, we've seen it, but seen it deleted.
Notwithstanding anything contained in any other provision of this Act, no non-testamentary instrument relating to immovable property shall be accepted for registration unless the Deputy Commissioner of the concerned district issues a no objection certificate containing the description. This is the problem. Therefore, my lords, at clause 5 of the ATC at 48,
You have an obligation to get those permissions.
that obligation
You have
they
to
took
file
over.
2 suits anyway, leave it at that.
My lords, I am only on my lords on the relief, my lords. 49, if your lordship says, if there is some defect in title possession, there is a remedy provided in the agreement itself. Clause 5, your lordship sees at 49. It provides for refund with interest.
Yes.
So I am willing to, my lords, refund with interest.
Then that's okay, that doesn't matter.
My lord, today, my lord.
The purpose is completely lost. No, but thank you.
My lord, my lord, only thing, my lord, no objection certificate. Even today, there will be a problem. Therefore, the specific performance.
The classic case where $43 lakhs for you.
My lords, procedure, well, I understand, my lords, it's a low, but it's a grave error in law committed.
What is the error?
I'll just point out, my lords, we have not relied blindly on the value given by DRI and have not followed any procedure under the valuation rules.
Isn't
In
that
fact,
a
to the
transactional value?
yes, my lords, may please have paragraph 14. The impugned order renders a finding, or my lords, paragraph 7 at page 87. My lords, may please come to 87 at paragraph 7. This is the order in original. The goods imported, my lords, have it? The goods imported under bill of entry, so and so have been found to be misdeclared with respect to
Why
thickness
did
and
you
quantity.
not ask for additional information from the SSE? If you had a reasonable doubt about it.
My lords, we are not.
As per valuation rule 12.
Which is exactly what has been done. As per valuation 12, my lords, a contemporaneous data was sought for. And we have relied on the contemporaneous data for similar imports.
The procedure under the established rule 4, 5, 7 and 8.
Yes.
That has not been followed.
We have, so because it is not.
What is not followed?
Relying on
No,
his
please, may I only please come to the findings in the order in original at page 118, para 16.2, the findings begin. Please see issue number 2 framed by the order in adjudicating authority at para 16.3, page 119. Please, my lords, see the second question framed by the authority. My lords have it?
119.
119, paragraph number 2. Please see the second question framed. Whether the value of goods as detailed above requires to be rejected under Rule 12 and further redetermined under Rule 5 of the Customs Valuation Rules is a question framed. He answers this question, my lords, at paragraph 16.5 at page 121. My lords may have 121. Now I take up the second issue as to whether the value of goods as detailed herein above requires to be rejected under Rule 12 and further redetermined under Rule 5. I find that there is evidence on record to indicate that the goods have been found misdeclared with respect to thickness and quantity. Therefore, the value declared by the importer is rightly liable for rejection under Rule 12. Since the value is rejected under Rule 12, now the value of such goods is required to be redetermined by proceeding sequentially in accordance with Rules 4 to 9. I have perused Rules 4 to
2 lakhs to 43 lakhs.
This
amount is also very small.
Manoj, this exercise is conducted. The impugned order says, Manoj, we have not conducted the exercise. It's exactly contrary to the record. They say the impugned order.
Worthwhile for you to contest this on income tax.
It's a repetitive
It's
issue,
just
Manoj.
10 lakhs rupees.
Manoj, what now happens is, if
it is very small.
Only request. If this practice is shunned down, what happens is, Manoj, all authorities, my lords, customs preventive, customs normal department, DRA, they all work in tandem with respect to imports and examination investigation. This is a case where, my lords, a request to DRA was made and they gave us the data, but we still followed the procedure under the evaluation rules.
We'll keep that question open for you.
As it is.
While we are not inclined to interfere with the, it's a statutory appeal, right?
My lords, this is a statutory
order, right?
Yes. My lords may consider, my lords.
So the fact that the amount is what, 10 lakhs?
I'll just 21 lakhs.
The duty, the revised duty.
21 lakh 84,000.
No, it not 10 lakh, the redemption duty of 1 lakh also. 10 plus 1, that's all, 11 lakh.
So the listing pro forma says 21 lakh. I'm sorry.
We calculate.
As it.
In view of the act, the duty, imposable duty is a small amount. We are not inclined to entertain the appeal. However, the question of law raised by the party is kept open for being considered in any proper way.
Very great.
Item 25. Short accommodation in this matter.
Why, ma'am?
Saturday, I circulated a letter in this matter, my lords, due to time.
Ex-party decree.
My lords,
What happened?
my lords, the senior counsel engaged in this matter is hospitalized.
No excuse.
My
First
lords,
work, you prepare and come.
my lords, I have.
Yeah, that's any other time you would have granted.
My lords.
Don't say senior counsel. Yeah.
My lord, Saturday morning only I got the information. Suddenly I circulated
saying
letter,
that.
my lords.
Youngsters should stop taking that plea at all. We'll pass it over, get ready and come.
My lord, short adjournment kindly grant.
We will see after you tell us what the matter is. Passover?
27.
26. Wait, please. There's an application under order 18 rule 3A. Very good.
Read it. Yes. पहले आने दो भैया, jump the gun. Let us go forward. Wait, please. The application under order 18 rule 3A, there are 5. When should the permission be obtained if a witness is to be examined? 5 judgments which say it should be obtained at the very outset, 5 judgments which say it can be obtained later, and 1 judgment which says it can be obtained in the middle. Lordship, you see, just see the tabular statement I gave. Different high courts are taking a different view. Now that 76 amendment was brought into the statute book because witnesses were being examined later to cover up the lacuna. 5 judgments, Your Lordship. I won't bother Your Lordship with the reading of the entire thing. Just see the 5 judgments. 5 judgments say I can obtain permission I should obtain permission at the very outset if I want to examine a witness later. 5 judgments which say I can obtain it later.
May have been, Mr. Somyajulan. May have been.
But today the position is, my lord, if the law is not settled.
What is the prejudice?
Beg your lordship's pardon?
What is the prejudice for you as a defendant?
If my witness, the prime witnesses were examined in this case, and 2 years later
It's not as if
the plaintiff comes later,
It's
man.
not as if he never evinced any interest in examining. There are certain circumstances because of which.
No, the only question, a limited question that I am seeking my lord to see is, when should the permission be obtained?
Not a case.
Then your lordship may leave, because one of the findings is that I've given up my right. At least leave that question open so that tomorrow I can point out to the court that lacuna is being filled up.
Okay, question of law kept open.
Oblige.
My lords, this is a case, my lords, 2020 Act upheld, 2022 regulations upheld. Private colleges are giving admission to. My lords?
Why is it coming before us?
My lords,
Being heard before another bench.
Justice Pardiwala, my lords, is hearing.
Pardiwala, but there the issue is under section 14 similar.
No,
but here, my lords, it's an interim
all
order.
the orders passed by that bench.
Yes, my lords. May I just pass on that?
Why is it coming here?
This is a fresh matter, so my lords.
It's a fresh matter.
This is a fresh matter.
Fresh
this
matter,
is against an interim order.
The same bench.
My lords,
My lords,
before the
one thing, my lords, if a stay can be granted on the judgment, my lords.
Of similar questions of law being considered, law and fact being considered by the coordinate bench. Registry may take instructions to list the matter before the same bench.
Please, my lords.
My lords, if it can be directed that it may be listed on
immediately.
Immediately. My lords, if not tomorrow, my lords, apart from tomorrow, any other day, my lords, may direct for the listing.
Get it listed immediately. Thank you.
Except tomorrow, my lords.
But for consistency only, will not tomorrow. It won't come tomorrow. Don't.
Much obliged, my lords. I'm traveling, my lords. That's the difficulty.
It won't come.
My lords, a stay in the meanwhile, my lords.
Won't be proper.
Well, it's the larger repercussions of this are serious. 28 fellas. The larger repercussions are serious. The Electricity Act is an autonomous, self-contained act. I have a show cause. I am doing a show cause reply to the authority. He's hearing me, Your Lordship has it in excise, in income tax, in sales tax, in hundreds of matters, mining. In the middle of that, the PIL petitioner who has activated the show cause, no doubt, no problem, we are not on that. We don't want the PIL order to be changed. Your Lordship allow him to intervene in a proceeding where the officer is hearing me? But has it ever happened? The officer will hear me and then pass an order. He'll levy a charge, he'll not levy a charge.
It's a question that we were intending to examine at one stage because commissions is permissible. Commissions, it's permissible.
No, only when Lordship is right. Your Lordship has done those cases where TDSAT or commissions have a public consultation. Your Lordship has a tariff, for example. In the electricity, Your Lordship is absolutely right. In TDSAT, you have a consultation process.
They asked them to participate and appear before the agent, is it?
The statute,
JBVNL.
in the statute Your Lordship is mentioning, there is a statutory approach to have a in rem intervention. Now, just note one more thing. There's one additional point here. This is very serious. Just keep the note here. This man who is a PIL, I'm not on the PIL order still, has his affections limited to me. He files this complaint.
Energy watchdog, no?
Energy watchdog is the same as infrastructure watchdog, both by Mr. Anil Kumar. He in the last 3 months, kindly hand it over, please, sir. He files 3 complaints only against me in the entire energy sector. And Odisha and Jharkhand only. Just see that.
You're not on the personal attacks.
And there
We
was
are-
a
we are
lot
on-
come
we
for
are
my
on the
confidential material. He will come and listen in the
It is
statutory proceeding.
confidential in fixation of tariff.
No, it's not tariff. This is nothing.
It's
a
about
show.
telling we understand.
It is saying that
saying that captive consumption.
Whether you are, I'm grateful. Therefore, in that proceeding, they will.
Tariff only. What else?
No, nothing to do with tariff. With respect.
The sale that you make
Yeah.
to your captive towards captive consumption.
Yeah.
It is in that context that his complaint is
It
there.
is not
It is
fixation of.
mandative.
May I explain? So there are 5 points that I let me explain this. There is no fixation of tariff involved. There is no statute like TDSAT or electricity which involves the consultation. Now, what is this? This is saying an allegation in a PIL,
Without him, that's all we need.
all that we are asking for is that the show cause goes on without his intervention.
We'll issue notice.
That's all I have said.
You're only.
We were worried
you're
by lordship
interested-
last comment. That's all.
Not like that. We were just, when we ask questions, we are
Testing it,
thinking
you're
about
not
how the
testing it.
system is working.
Testing it.
Because there were two issues. Electricity tribunal doesn't have an avenue of hearing the consumers. Appellate tribunal doesn't have the avenue. That's a great lacuna there. But so far as the commissions are concerned, it is somewhat permissible. Unlike, you can't open it up like a public hearing in an environment matter. But the Act says that it is meant for consumers. But there is no window anywhere. We'll issue notice in this. We'll examine this.
Yes. Well, sir, the proceeding are going, he's coming. I have no problem. Proceeding can go on. I can be multi. He can't participate. Either he doesn't participate or the proceedings are stayed. Lordship issues notice to him. Lordship stays the proceeding for a short while.
Oh, star. Let them come. When is it listed for hearing? So rather drastic. This is a High Court.
No.
Done it in the 226.
4 weeks timeline is given to decide the show cause. Your lordship is simply say that it can go on without him.
Mr. I'm just asking you, one hearing, suppose he is sitting, what will happen?
No.
We're just asking you. Tell us.
Very well. Let me
Tell us.
The principle is very dangerous is first answer. Your lordship's
That's a
sentence,
question of
your
law.
lordship's precedent, not question of it has an effect across. Number two, this is a man, just see the note 1 page. He files only against me in 3 months in Jharkhand and Odisha. No other electricity company. He's clearly set up by A, my competitor, and B, this is a takeover under IBC of Adhunik.
What is troubling you?
What is troubling me is he's malafide
What, is he going to mislead them?
malafide motivated against me. The proceedings, the matrix is a statute, section rule 3, which does not permit of a trilateral PIL kind of proceeding. The officer cannot be hearing him and me together.
You are not told us a single point. What is it that you are afraid of?
No,
you are only saying threshold jurisdictional issue.
So, Malas, jurisdictional issue
It
will
is
have to be
asking
not
you-
on why not. It has to be on why, Malas. Yeah, it's a locus issue. It's a lack of jurisdiction. And Malas, for a person who has filed only against me, plucking me out, it's a selective thing about me only. He's affectionate. If he's a public interest petitioner, and Malas, there is also in these proceedings in captive, you have to give information to the officer, which your lordship knows is a special kind of information. PIL is pending, Malas. Your lordship.
There's a time constraint there. So anyway, you take out notice, Dasti in edition, list after 2 weeks. In the meanwhile, there shall be status.
That's all. Obliged.
After 1 week. Post
1 week.
We'll
take Dasti.
Put it immediately
We'll
after.
do Dasti.
So list kar lena.
Please serve it now.
Yes. It's doesn't list on first of April.
Very well.
Dasti in edition.
May please. Will delay, my lord, but the question is important, my lord.
First को मत करना, first को नहीं कर सकते शायद, है ना? 6th को लगा. Mr. Mahesh Agarwal, you are putting it up on 6th instead of. Yes.
There's a delay, but my lord, the question is important because the High Court 29. High Court at page 7 agrees with the settlement deed. Property is transferred to the trust. Therefore, the higher rate of interest stamp duty would be attracted. If the High Court agrees on that premise, then allowing the rate was a mistake by the High Court.
Property always remained with them, Mr.
No, does not. Lordship has page 35.
There is a transfer for you to impose.
No, no, page 35. It transfers, it
Such a
goes.
huge.
SN
stamp
Mathur
duty
answers this question, Mother.
on a
SN
trust
Mathur is dealing with the UP Trust Act, UP Stamp Act. Have page 35 for a minute. The trust.
What's the point you're making?
The point is that the higher rate of stamp would be attracted. That is what the finding of the collector. And the High Court agrees with us.
What for?
High Court agrees at page 7 that it is a settlement. Once you say it is a settlement, then the higher rate would
Who
attract.
owned the property?
It is now with the trust.
From whose hands?
It went from Rajendra Prasad Shukla.
Who is a trustee?
He is not a trustee. Not here. Not a trustee here.
From whose hands it has come to the trust?
From Rajendra Prakash Shukla. Page 35.
Who is he?
He is an individual, Manoj.
Just
He was
sale
managing
to
the
the trust.
temple earlier.
Is it a sale to the trust?
I'm sorry, man.
Is it a sale to the trust?
No, it's a settlement with the trust. That's the point. 224 says settlement. 224 says settlement. I need not sell it. 224 says settlement. So if it is a settlement, then the higher rate of stamp would be attractive. That's what 224 says, Manoj. And say, look at page 7. Even if it's both, page 24.
If it is both as per section 6, it will be the higher.
Yeah, man, Lush will issue notice on delay, man. Can impose cost also. I have no difficulty, man.
No.
But the question is, no, I mean, I feel
Anyway,
fair
it doesn't
also.
matter. Notice.
I'm a blessing.
Lords, I'm seeking a Passover.
Redact.
I'm led by learned SG in this matter.
Okay, what is to be done now with these matters, Mr. Diwan?
This fellow's notice has to be issued, Malas, and matter
Why?
has to be heard. It's been heard many times, and it was
No, it
supposed
was-
to be
it-
disposed of at a final.
We haven't heard it for long.
No, it's
Some other bench.
No, I'll tell you, Lordship, it came to a different bench. The intention was to dispose it off at this threshold. So formal.
It's been pending since 2024.
That's the problem. Your Lordship, let me explain. We were both there. I mean, it's difficult to explain like that. It came 2 or 3 times before a bench. At that time, I believe it was Justice Nagaratna, if I remember, headed by Justice Nagaratna. Then it went into limbo. Each time the learned judge had wanted to decide it.
Are we to hear or by mistake it's coming here? How?
No, not mistake. No, it's been assigned. Your Lordship may actually, I mean, either of two things. Either issue a formal notice, because I can tell Lordship, both my learned friends were here. It was heard at some length. And Malas wanted to be disposed of.
Not to be heard so much of it.
No, true.
What is there to be heard for at length?
No, I'm saying in case they want to, we can finish it straight away. We're ready to finish it now. Only thing is,
First
if they
up.
want.
We can do it.
Yes, very well. I'm ready, Malas. She is saying something about.
What's the problem?
I'm just seeking a Passover, my lords.
Passover.
Well, it's today. Can it be a Friday or Monday? Malas? Some problems today. Malas. Friday or Monday is only required.
All right.
Whichever your Lordship gives. Malas. Monday?
Fine. Next week. That doesn't matter. We'll accommodate.
Yeah.
2 हफ्ते के बाद लगा देंगे.
Then we'll have to argue. No, then we'll.
It's not.
Trial court is proceeding on.
Look at it at a larger way. Look at it. There is the question of we granting an interim order now after 2 years.
Then your Lordship pass it over. The trial court is hearing it on 30th. I can't see. The trial court will either pass it over.
All right.
It's a point in sentence. One sentence is.
कुछ भी नहीं है इसमें. Nothing.
If you can't adjourn it, then you have to pass it over and do it today. That's all.
Witness wants to depose what he heard.
Yeah.
So,
In a sentence, while Lordship is passing over, just note this sentence for us. The case is that my witness, who's physically deposing to what he saw, is now redacted. The same redaction of the physical deposition was refused up to the Supreme Court earlier. Yes. Now, that's the short point. I'll make it good today and pass over all balloons, whatever.
The earlier order.
Yes.
Okay, we'll do one thing. You have a note or something?
yes, we filed written submission and volume 4.
That's why I'm saying this is well, formally.
I see. Written
The Lordship is misled by the fact
Is there any interim order here?
No.
Arbitration is going on. That's going on.
Yeah, it's
Yes.
Huh?
No, and
No, evidence, my lords, our evidence will start.
It's going on. Matter is going on there.
Yeah, that's why 30th. On 30th, the learned judge will pass an order. My evidence will be excluded. So
Put
I'm
up
saying
on 7th.
defer it by consent. Defer it.
7th.
Then let me let her agree to defer it. On 30th, she will pass an order excluding me.
You not say anything.
Well, the
7th.
last order,
Post on 7th.
last opportunity. Well, I'm only saying.
Post on 7th. 7th?
All right.
From today to 7th, there is nothing.
Well, we will then make a statement here that we are going to ask the
You do whatever you want.
defer it. Well,
7th.
we have
It's been pending since 2 years. Next.
Your lordship is, on the.
You want it earlier than 7?
No, your lordship will have to put it 6th. As far as I know, your lordship were in the CB, the first one. I don't know about this. I'm in the CB, the second one.
I don't think I could be there because.
The 7th, I'm there in the Sabrimala and the other.
Keep it 6.
6th is better.
6th. We'll say
Just in case.
6th. Oh, that's starting from 7. Most probably. We don't know. It's up to him. Salute.
You show it from Me, please, my lord. My lord, here my
Which item? 31.
Item 31, my lord. Here my suit has been rejected, my lord, under Order 7, Rule 11.
711.
Yes, my lord. The prayer in the suit is that this entire thing is forged and fabricated. I have no remedy, my lords, under 17. My lord, your lordships have already taken a view where fraud is alleged, my lord.
DRT.
Then, my lord, it has to be gone into in the suit. Now, my lords, the High Court.
This is a complete misuse.
No, my lord, I'll just point out, my lord. My lord, I'll just point out, my lord.
Case, a complete clear case of action.
My lord, kindly see, my lord, what has happened here. 10th of April 2013, my lord, I hand over, my lord, my property title deeds, my lord, as a, my lord, guarantor. And, my lords, within 6 months, because no final agreement is executed, I withdraw it, my lords, on 24th of June 2014.
2018 you file.
2014 itself I withdraw.
In its seating.
Yes, my lord.
2018 you file.
Yes, my lord. That's only when the securitization measures are taken.
As if you are unaware of
immediately, my lord.
Title deeds were kept with them.
Yes, my lord. 2014. Kindly have a look at that, my lords. My letter, which is at page 155. Lords, page 155.
Sorry,
the suit by the other guarantor is pending, my lords.
Not
Lord, just have a look at my prayers, my lord. Just 30 seconds only, my lord. Please have a look at the prayers. How can this be gone into, my lords, in surfacey proceedings, my lord? Kindly have a look at my prayer, which is, my lord, in the IA 76810 at page, my lords, 20.
You wake up at what
page 50, my lord.
Devda?
My lord, limitation. My lord, my suit has not been, with respect, my lord, my suit has not been dismissed on the ground of limitation. The trial court only says, and that too, my lords, this suit has been rejected without even hearing me. That also is a point, my lord. Kindly have a look at it. Lord, it was transferred to the commercial court. I was not even heard, my lord.
Dismissed. Next.
Lords, then, my lords, may I only make a request? Lord, now the trial court says, my lord, and the High Court says all these points have to be urged, my lord, before the DRT. Now, my lords, the DRT refused to hear me on the ground of pre-deposit. I filed a writ. All the questions, my lord, may be permitted because I've raised all these questions here.
Are permissible before.
Yes, my lordships may say that since your lordships are dismissing, because the High Court has given findings on merits, my lord. In Order 7, Rule 11, please have a look at, my lord, the findings of the court. If your lordship
the findings returned by the trial as well as the High Court in Order 7, Rule 11 proceedings are confined to the confined to the maintainability of the suit, and they shall not have bearing on the proceedings before DRT.
Grateful, my lord, extremely grateful.
Lordships, an unfortunate situation where, my lord, I've been paid only 1,500, my lords, for 11 years, my lord. 11 years, 1,500 is the salary. In fact, in pursuance of a contempt, my lords, what they do is...
But then we have, looking at the judgment,
please,
that about your salary part of it, it's no part of the judgment.
No, salary part of it, my lords, they asked
Idea is
them,
coming about contempt.
my lords, salary part of it, they asked the authorities to consider it, my lords.
Judgment.
My lords, in the judgment, it only says that it has.
But actually, you have unfortunately lost out in filing a contempt. But so far as the salary is concerned, that's an independent cause of action. It has got nothing to do with the contempt. You can independently file a writ or a whatever.
Lords, I've been litigating for the
Arise and
past
shows the
40 years, my
order.
lords.
Shows the order.
The,
Contempt of which you are alleging, where is it that the order directs with respect to UGC salary? Show us that.
Lords, the order does not, my lord.
Then how does contempt
Lords,
play?
para 3, it reproduces, it only says that you work out with the authorities, my lord.
Now, how does contempt play?
Lords, no, what happens is, insofar as my reinstatement is concerned, my lord.
We have recently said
Lordship,
that your lawyers are advising to file contempt, whereby the clients are losing their opportunity to challenge the impugned orders because courts are dismissing contempts. And main impugned orders remains as it is.
No, but what happens?
Again, exactly
Your
the same
lordship's
thing happened.
recent judgment is also that, my lord, courts cannot pass an order asking them to
Show
consider.
us, we will issue notice. We have no hesitation. If you show us in the main judgment, there is a direction with respect to UGC salary.
Lord, there is no direction.
How does contempt is maintained?
Lord, contempt in so far as two aspects, my lord, because they did not reinstate me, my lords. And thereafter, my lords, when the contempt was heard, my lords, my superannuation had already taken place, my lord. Now, what happens now, my lords?
Okay, open up and then see, you make your argument on the basis of the order, 12th April 2004 order. Show us that.
My lords, 12th,
There is no direction.
my lords,
Once you are admitting what is there then. Okay, while we are not inclined to interfere with the order passed by the High Court, the petitioner is entitled to avail such remedies as are available to him
to her, my lord.
in law with respect to the claim relating to UGC salary. Full stop.
It should be her, my lord.
Her. It is because of such
But I am ready, my lord. I file additional documents. I am also submitting small.
Tell us, Mr. Nagamuttu. Tell us.
Lord, if you
How is this possible?
Lord, I will, Lord, you Lord, kindly give me, Lord, I have to trace my title,
We have
1892.
adjourned it at your request about 10 times.
But I will argue the matter. I am not asking for adjournment. But I will argue the matter.
There's nothing in this.
Lord,
In unfair register, you are only arguing. You remember the first day when you argued that it is actually not a marked document.
yeah,
Not a,
that is there.
you see,
That is there.
they have filed a government has filed a
Original.
counter.
You Lord, kindly.
Certificate copy of the
Lord, not only that, but I have filed. You Lord, kindly see how the trial court has dealt with it. My Lord, you Lord, kindly give me 15 minutes time.
Mr. Nagamuttu,
No, my Lord, I am ready to argue the matter.
Dismiss,
You Lord, no, you Lord, kindly hear me, please. My Lord, from
we have issued notice in this, Mr. Nagamuttu, only on the ground that you said this is not a original document.
Yes, it is not original.
See, the original need not.
It is not original. It is not original. You Lord, kindly peruse that. Even now, I can demonstrate as to how it is not original.
Collector custodian of the
My Lord,
document.
please, sir.
Certificate copy has been
Sir, please wait. This is certificate copy obtained from the court. What is produced by the court is not. Your Lordship, kindly come to the judgment of the trial court.
Nothing.
Your Lordship, kindly give me time. Your Lordship, kindly give me time. Or else, if your Lordship may kindly call it at the end of the board.
Nothing.
Your Lordship, kindly call it at the end of the board. I will argue.
End of the board, right?
Grateful.
There is nothing in this, Mr. Nagamuttu. We are telling you.
My Lords,
End of the board.
My Lord, I can demonstrate.
End of the board. End of the board.
If your Lordship give me 15 minutes time, my Lord, I
End of
can.
the board, Mr. Nagamuttu.
Correct.
Come back.
Grateful.
There's no question of 15 minutes.
My Lord, very valuable property. My Lord, 1970, my Lord, order was passed by the government.
Illegally occupied and continued.
My
Next.
Lord, I am not illegal. My Lord, this impression, my Lord,
Come back. Come back.
I should say, my Lord, that this impression
back,
should
come
go
back.
first.
Come back.
Grateful.
Since
Counter served today morning. Have to notice matter counter affidavit served me today morning. Probably it is not on record also, probably before your last.
Suit for specific performance.
Yes.
Again 711,
711.
And 30, 50, 70.
Barred by limitation.
40, I constructed house. I paid full. There's no performance on my part. Everything amount paid, constructed out in the year 15. 17, when he refused, I issued notice in the year 17.
इसको notice.
Request and moreover,
Notice किया sir.
After notice.
After notice.
We'll hear you. We'll hear the matter. Next, give a date. Next.
Please, my lord. My lord, in item 35 on the last date of hearing, your lordship has
settled or not?
Yes, my lord. I have received a letter, my lord. Lordship may just see these two letters, my lord.
No, I don't know.
Now, what happened, my lord? The other side has sent me a letter, respondent number 2, that they are in the process and finally your lordship may grant 4 weeks time, my lord. Actually, why?
Respondent number 3, contesting respondent
All right.
number.
It's settled. It's getting settled.
Yeah, there are talks.
In view of the statement that at the bar, common submission at the bar, the matter is at the verge of settlement, adjourned by 4 weeks.
Yes, my lord. Yes, my lord. Actually, Lord, we want possession of the property. That's why it is getting delayed, my lord.
Understand.
Highly obliged.
Your lordship, in the 36, I have circulated a letter for counterman.
36, is it?
36. Circulated a letter for counter.
In 36?
36.
All right.
Your Lordship, there is an interim order that may kindly be extended.
Yes.
Applied.
Let's make a confession upfront.
37?
Well, 37, my lord, had posted it today on my request because there was some urgency. But I have a small confession, my lord. I was supposed to submit a bunch of treaties. But this deals with the India's power to enter into treaties with other countries. There was a bereavement, which is why I couldn't submit it, my lord. Would my lord have it next Monday, my lord?
Lord, my request is that in case the respondents number 2 to 4 intend to file a reply, they
Why you have filed an appeal? Anyway, we'll examine it.
We'll also put a short reply with us and on behalf of respondent number 1.
Any short date, my lord?
Yeah. Okay, we'll put it up. 14th, ko laga na? 14th.
Grateful, Lord.
Grateful.
Grateful.
So 38, your lordships had adjourned it on the last occasion to await if in case somebody were to enter appearance for the respondent. Otherwise, the service was complete in December.
Yeah.
And it's a transfer petition on behalf of the wife.
DB Act pending है वो.
Transfer petition, no?
Yes, my lords.
Actually, both at Vadodara. All right. Transfer.
Very deeply obliged, my lords. Grateful.
Yes, my lords, we have filed the counter, my lords, but it is still not on record. However, I would like to just make a small submission, my lords, that the transfer petition has been filed by the petitioner only to, with the ulterior motive, only to stall the transfer. Yes,
Your child is with the mother.
but I am the.
Just a 6 years old child.
It is an
the child and then go around.
It's an adopted child, my lords. Both the parents have the
Child is a
co-equal
child,
rights.
saying.
And my lords.
My lords, may I kindly submit this? My lords, all I am getting is, my lords, only 2 hours in a month, my lords. I am the father. My lords, the consent was from both the parents to adopt the child.
We are concerned only with transfer petition.
But my lords,
a transfer petition.
Also,
1 minute. Child is with the mother.
Yes, my lords.
And mother is at Karnataka.
Yes, my lords.
And the guardianship petition could not have been filed at Hooghly.
My lords,
As simple as that.
my lords, it was already filed because she was in Hooghly at that time, my lords.
At that point
She
of
was
time.
in Kolkata. Now, my lords, the difficulty is I have a mother, my lords.
It's an admitted fact that you are for the.
I have a old mother also at my place, my lords. Just,
That makes no difference.
my lords, I can pay for the expenses if she can travel to Kolkata, my lords. I can pay for the expenses.
You'll have to transfer.
But my lords, that will mean that I won't be even able to meet my daughter, my lords. We can look out.
Daughter is with the mother. You go there and then.
My lords, I have visitation rights. Once in a month, I'll also have to travel to Karnataka every month, my lords. My lords, we can have a meeting.
Which year is this filed? 2022.
2022, my lords, it's at the final argument stage.
Okay.
My lords,
Why
we
have you
can have.
come so late, Samira?
No, my lords, I have.
2022 guardianship petition.
No, my lords.
Anyway, you should have taken the objection that At the time when it was filed, you were staying there.
I was staying in Hooghly. Millards, what has happened?
problem.
She has now found a job. She's working with Hindalco as a assistant general manager.
Where?
At Belagavi, at Karnataka, which is more financially, Millards.
Belagavi, okay.
Yes. She's working as a assistant general
But
manager.
then the problem is that the case was filed at the time when you are at
Yes, I was there.
Hooghly.
Yes.
Now later on you shifted. Which year did you shift?
Millards, I shifted
To Belagavi.
Lordships, yes.
Well, it's 2024,
2020.
without even informing me and the court.
No, that is Millards under section
Right.
44 only
But
applies to a court appointed guardian.
You took the child and then went away. Was there any interim order in that you will not?
No interim order restraining me to move anywhere. Section 44 would apply only to a natural guardian.
My visitation rights were.
What stage is this, Samira?
Millards, it was that stage I am not very.
Malaj, it's at the final argument stage. Malaj, I have instructions. Malaj, it is just going to be over.
The witness
I'll
is
take
examined already.
instructions, Millards, if your Lordship.
Witness is already examined.
Evidence is also over, Malaj.
Samira, leave it at that.
Millards, Lordship, may pass it over. I'll take instructions. I'm not very much aware about this because it does not
It doesn't
reflect
matter.
from the
fact
papers.
that guardianship was filed by you at a time when filed by her at a time.
Millards, I'll tell your Lordships what has.
It is you have created a situation.
No,
Not-
Millards, I'll tell your Lordships what had happened in this matter. Your Lordships may just kindly have page D, Millards. I have explained that, Millards.
Tell us.
Earlier, I was working with a company called Aditya Birla. Millards, he's a very rich businessman. He's a Millards business. He's a overseas businessman, Millards, with business across different countries. He deals in steel. Just kindly see, Millards, page D. Why I have explained that, Millards.
But you created a situation.
No, Millards, I'll tell your Lordships
Therefore,
what.
it's not
Millards, no, Millards, sometimes your Lordships would, Millards, in the case of a woman, Millards, your Lordships perhaps may have to take a little, Millards, realistic view about the kind of problems which. Just kindly have a minute. I understand. I appreciate, Millards, what is falling from Millards. Just kindly see, Millards.
But from the stage of.
Kindly see the explanation, Millards. Page D for a second. Millards. Page D, Millards. The petitioner earlier worked as a senior manager with Aditya Birla Insulators at Risra, West Bengal. In December 2024, she moved to Belagavi, Karnataka to join as an assistant general manager at Hindalco Industries, Belagavi, Karnataka for a better career opportunity and financial stability. The present company has a stronger presence in the market compared to the previous company with larger clientele and thus more job security. The relocation was.
Mr. Samiran, it's not just you in the picture. Enormous time of the court, it has spent so much time and it has conducted the proceedings at the verge.
Millards,
Sorry, dismissed.
Yeah, at that point in time, Millards, your Lordship may just allow me, Millards, pass it over. I'll take instructions on what is the stage because right now I'm.
Pass over, come back.
Pass it over, yes. Grateful.
May I please, Lordships? Lordship, this is a transfer petition filed by the wife. My Lordship was pleased to issue notice on 15th of December. Thereafter, twice the matter was adjourned, but nobody has entered the appearance. Even on the last occasion, my Lordship was pleased to give the further time. Please, Lordships. Obliged.
Can be disposed of in view of the subsequent developments. In view of the subsequent developments, government said, let the DEO be the manager till the civil suits are disposed of. High Court said, let the erstwhile manager continue till the civil suits are disposed of.
Grazing land.
Now the civil suits are disposed of now.
Why is this matter? What is this
Now
matter?
the civil suits are over. All that I want is, let the educational authorities take a call.
Sorry, but
Milord, High Court said, Milord, kindly hear me. Milord, government said, let the DEO be the manager till the civil suits are disposed of. Milord, now the High Court said, till Milord, additional documents I have produced which show that the suits are now come to an end. Suits are not pending. Let the educational authorities take a call up. Appointment of a manager to an aided school. Milord, there was only an interim arrangement by both the government and the High Court. Government said, let the DEO be the manager till the suits are disposed of. High Court said, let the erstwhile manager continue till the suits are disposed of. Now the suits are disposed of. I don't want any relief. Let the educational authorities take a call. In the light of the fact that the suits are disposed of, additional documents.
with great respect to my learned friend, Milord, I would respectfully submit for your Lordship's kind consideration
No suit was filed as directed by the learned single judge in the division bench. Please have a look at my counter affidavit.
That is for the
He
educational
was
authorities
removed.
to take a call.
He was removed from the membership of the society and office bearer.
Not necessary.
Yes,
Dismissed.
it was left off.
Dismissed.
The suit. He did not file a suit.
Going by the High Court order itself, going by the High Court order,
As well as the division.
going by the High Court order itself, till the suits are disposed of, erstwhile manager can continue.
Can't keep him.
Suits are over now. Suits are over. How can he cling on to office? I fail to understand. Suits are over.
To understand how a responsible counsel can mislead the court. I'm sorry. I'm sorry.
No.
My voice.
First of all, such personal attacks can never be tolerated.
This is
If you have
actually
studied the brief, you know who is responsible.
Poor breath, Mr. Chidambaresh.
Yes.
Not a case for us to interfere. Thank you. Dismissed.
This matter, the government had to file a counter affidavit. They have still not filed a counter affidavit.
Whether does it may. Otherwise, the matter can be the only issue before the High Court was whether impleaders in a contempt, whether that application is pending, can be maintainable or not. The High Court has said impleaders in a contempt can't be impleaded. Be that as it may, my lord, it can be.
You haven't filed a substantive.
No.
No.
Nowhere?
I'll tell your lordship what happened. So in this case, there are 2,500 poor families living in these lands for the last more than 50 years.
Where is the substantive petition that you have filed?
No, we didn't file. Actually, in a PIL, which was filed by this gentleman,
when
in that PIL,
implementation,
an order was passed saying that determine whether this is marshland. The DFO said this is not marshland, that this is only grazing land, and for grazing land, the government has a policy. That's how it
The High Court has only.
And the High Court refused to.
Petition, इनका application regularization pending है.
We didn't need to. Actually, my lord, in this contempt petition, prior to that, that PIL was disposed of.
No regularization shall be done.
What happened to the contempt now?
The High pending matters because it's stayed because of them having filed this.
Oh, this is stayed.
Yes. From 2022, nothing has happened.
My God.
We
And
were the
submission
people,
regarding.
we were the people who were being evicted.
Mr. Prashant Bhushan.
Yes.
Simple matter would have been over if we had permitted you to be impleaded. And you would have been asked to clear the matter.
Permit us to be impleaded.
Yes.
And let the High Court hear us.
Yes.
Because
no difficulty, my lord.
Yes.
That's all that it is needed.
All that was needed.
Why have you kept it pending and dragged on the matter for such a long time?
That palatial houses, to say that poor, I don't want to say much.
Palatial.
We have photographs.
Government has said very clearly
How it all happened.
that we are giving pattas only
land,
to the
marsh
poor
land,
people, not to any wealthy people, not to any commercial
In
establishment.
fact, when the writ was filed, there were only 111 encroachers. Till the time the contempt was filed, there are thousands of encroachers today.
We know there will be some builder behind.
Huh?
It's natural. This is how systems.
And even that contempt, if your lordship sees,
No, not necessarily.
that contempt, what happened was originally there was a PIL saying that this is marshland. That PIL was disposed of.
Wait a minute. Just take us through the High Court judgment. Why did he reject it? Just tell us.
Yes, my lord.
Is
High
there
Court
it- there
judgment,
seem
the
to be
impugned
multiple-
order.
Multiple orders?
Impugned order starts at,
What are the orders?
Well, it's 15
yes,
to
my lord.
2022 and 7
Page
to
23, page 23,
In which matter, 42 or 42.1?
42.1. 42.1. In fact, my lord, state has sought time to file a counter affidavit.
What is that?
Because this
state had ended
matter,
up in
this
2022.
matter
Can
should
you just
be,
do one thing? Just
should be
give us a
dealt with
two-page note.
in this
Very
court.
well, madam.
A two-page,
This-
we'll take it on Wednesday.
Yes.
Let state also come.
Let the state file.
We will do one.
State stand was very clear.
matter
I'll
was
show their
pending here.
affidavits of the state
Matter was
saying that
pending here.
we are regularizing them.
Just talking, sir. We are also talking sometimes. This matter has been pending since 2022.
Yes, madam.
Only question why it has come here is because they were not given an opportunity in the contempt when they went for the first time. High Court might say that so far as their removal is concerned, that should be in accordance with law and give them an opportunity.
For removal of wherein for the
Have you issued show cause notice to them?
Yes.
Some enclosures have accepted the notice, some have refused to accept, some have already shifted out. So it is difficult to make an omnibus statement about all enclosures. What initially began as a few enclosures.
In every case where the petitioners are before us, whose applications for impleadment have been rejected, in all those cases, show cause notices have been issued.
Specifically, person by person, I'm not
So we will clarify only that portion, and we will ask the High Court to examine it, give them an opportunity, and tell them.
Very well. In fact, my lords,
protect
show
them
cause
with
notice, that proceedings have also attained finality. The challenge is what happens is, my lords, when a notice is issued, because it's sold, so therefore you can't identify the person.
Give us a two-page.
Lord, what has happened in this case, if your lordship just sees these facts.
We will take it up day after tomorrow.
An original PIL saying that this is marshland, therefore people cannot live here. The state filed an affidavit saying that we have examined it, this is not marshland. Thereafter, my lord, the High Court directed a committee appointed, headed by IIT, etc. The government filed repeated affidavits in the High Court saying.
Day after tomorrow. List it day after. We'll dispose it off.
Very well.
You take instructions.
We'll have a note also just to assist my lords. Very obliged, man.
Day after tomorrow.
All right.
They should get some place to contest.
In fact, government said repeatedly in affidavit saying that we
shouldn't have said that.
I'll show that those parts of
Day after tomorrow.
affidavits of the government in the High Court where they said that we are giving them pattas in this very land, and we have identified alternative grazing land for this.
Give you them.
Yes.
In fact, they were represented also in the earlier proceedings. I'll make that good.
Day after.
Very well.
Letter. Is there a Chingon?
No, sir. Lord, 44 is a contempt petition. See you. मुझे वो निकालना contempt first. Page 35. My lord, this is a contempt. My lord, this is a contempt petition. Please see the order for which we say there is contempt. It is at page 35 of the.
Madam, 44. 44.
What is this? Is it?
My lord, here I'll just indicate to your lordship what
is it coming now? What is?
My lord, I'll tell you, lordship. My lord, I am the. This is a case of.
Was being heard by another bench?
No, my lord, your lordships are part of the. I don't know whether another bench, but. Just come here. Sorry, my lord. 19/124, my lord, order your lordships were not, my lord, on the bench, but I believe that on the previous order, which your lordships will find at page 126, which is the order prior to that, which is at 126, it was your lordship. Now, my lord, I'll just indicate, this is one of the most unfortunate cases where the liquidator, my lord, and we have said so on affidavit that this is a liquidator who's hand in glove with the original promoter, not giving me possession of my land by saying that until the land and machinery on top of that is given away.
My lord, so initially, my lords, when the land and yes, my lords, I have. Yes, my lord. So, so my lords, today, my lord, no, my lords. Yes, my lords. Yes, my lords. Yes, my lord. Yes, my lord. So, my lords, today, my lords, unless and until, my lords, the entire sale consideration should have been paid, my lords, to the liquidator. My lords, liquidator should not have allowed, my lords, to lift up the plant and machinery, which the land which they wanted, my lord. Today, my lords, may I only apprise your lord.
Has notice gone in?
Yes, my lord, there are
Counter has filed, my lord. May I only say, my lords, one thing, my lords. First of all, my lords, as a liquidator, my lords, I tender unconditional apology, my lords, for the delays. But my lords, may only see this, my lords.
We are not interested in your.
So, my lords, today, my lords,
we want compliance.
Yes, my lords. So today, my lords, the situation is this, my lords. The new purchaser has handed over, my lords, the check of the remaining amount also.
However, my lord, since we have filed an IA before your lordship, my lords, SCC, my lord, says, my lords, has resolved that they will revive this sale to the new purchaser. And my lords, we are only seeking direction that 2 months, my lords, to be given to the new purchaser to lift the plant and machinery so that we can hand it over to, my lords, the land to the successful bidder, my lords.
Where have you said in your affidavit?
My lords, I have filed, my lords, one IA, my lords, which is, my lords, 44.1, my lords. IA number, my lords, 1937, my lords. It was, my lords.
In 44.1, you
Yes,
have
my
filed
lord.
the
So, my lords, even at that point of time when I filed this IA, my lord, the check was not there. But subsequently they made the payment. But my lord, in liquidation.
Show us the relevant portion.
Yes, my lord.
There is at page 21, I think.
IA number 14598.
No, my lord, 1937. my lord.
37. We filed a reply to this in which we have said that. What is the date of the IA? Okay.
But it's page 14 onwards, my lord.
There's no such thing.
One minute, let me- Something has to be recorded that I'll make sure it's properly. recorded. You want the possession, no?
44.1 is
And this is very interesting.
My lords, page 20, my lords, para 50 of my lords application. Yes, my lords.
No, this is the one. This is the one.
In IA, my lords. In IA, my lords.
An interlocutory application, praying for करके prayer quote कर लेना. It is in the affidavit. It is
which para?
Which paras, please?
My lords, the relevant para your lordship will find, my lords, at page 20, my lords.
20.
Para 50, my lord, the reasons, my lord. MA 1937. 1937, my lord. MA 1937.
Page.
Para 20 are the reasons and para 20, page 21, my lords. Page 20 and page 21.
It's only prayer, sir.
My lords, page 20 and page 21, my lords.
Because
You are referring to which para? Para
My lords, para 51 and 51, my lords.
Cosmos will direct it to pay. Who is appearing for Cosmos?
My lords, nobody, my lords, they are not a party, my lords. So, my lords.
No, but they have paid the amount.
Yes, they have. They have now, my lords. They have now paid, my lords. So, if your lordship will permit, I will.
This is appearing on behalf of the.
Oh, can I make one submission before lordship says?
1 minute. Official liquidator submits. ये पहला एक quote कर लेना with the prayer and.
I just want
in
to
relation to the prayer
itself, no?
The application. In the application, the following is stated. The para 59 and 50 and 51 you quoted. Then you say, Learned Counsel for the petitioner, official liquidator submits that Messrs. Cosmos has already paid the outstanding amount.
Outstanding, and the check for interest is still with me. I have not encashed, my lord.
Doesn't matter.
Yes, my lord.
Outstanding amount along with
the interest,
along with
GST, everything, my lord.
it is therefore prayed that in 2 months' time
Yes,
be
ma'am.
granted for handing over
Yes, ma'am.
possession. We are inclined to accept the prayer and grant time to the official liquidator to hand over possession to the petitioner herein, which will be compliance of our order dated 19/1/2024.
Lord, I wanted to.
This case, we are not disposing.
No, I agree. Lord, just one more thing.
Case after 2 months.
Lord, please make him also file an undertaking because on the last occasion he said the same thing on 28. This is of August 24.
Okay, he's already in contempt.
My lord, this is an order. This application is of August 24. On 28 January 25, he said he's ready to hand over possession. We are 1 year, 3 months later, my lord, already. So let him file an undertaking, my lord, is my great.
This is a preemptory order. Upon failing to comply with the directions, we shall proceed against the official liquidator in contempt.
Liberty also, my lord, to impede, my lord, the Cosmos, my lords. In case, my lords,
Cosmos is not required, it will only delay the proceeding.
if, my lords, the person who is supposed to lift the machinery, my lords, if they are not, my lords, lift
them out.
So, my lords, I have to
Move it
cancel
out.
the sale. So, my lord, then in that scenario, I have to cancel the sale and then it will again take 3 months, my lord, to hand over the possession.
See, now again is going back.
No, I am not
bound by the order of the Supreme Court.
I'm grateful, my
He
lord.
has to remove the machinery himself. If he has-
My lords, these are the machineries, my lords. Where would I lift it and my lords keep it, my lord? That is the problem, my lords. I am also, my lords, the officer of the court, my lord.
The compliance of the orders of
Yes. I'm grateful, my lord.
See compliance and ensure that there's no other alternative.
Absolutely, my lord. I'm grateful, my lord.
Please, Your Lordship, apologies, this matters has done several rounds before the court.
Content?
And MA.
This order is in the contempt. A notice has gone in the contempt, no? Check that.
Yes, yes.
Notice there, no?
Notice.
Contempt may order. 45.
Well, it's 45. Matters been to the Supreme Court several times. My lord, may I just explain what the issue is? My lords, there are these
Amines, is it?
Amines.
Parity.
There are two kinds of Amines. One who's on a salary of the cooperative department, and the others were on a commission. My lords, the issue was whether there could be in the same group of people, in the same cadre of people, there could be people.
27th March 2023 order, you may have to challenge, Mr.
Well, lords,
But instant you are pursuing contempt.
I understand. I understand, my lords. I realize.
Permit you.
My lords, there's only one thing that we would need, my lords, is your lordship give us liberty. We'll withdraw this matter. Liberty that we will seek our remedies before the High Court.
Yeah, we'll clarify. You may challenge it. That's all.
Gotcha.
Mr. Salman Khurshid, learned senior counsel, clearly states that submits that he would advise his clients to withdraw. No, why advise? Seeks to withdraw this contempt petition to pursue clients' remedies against the order dated 27/3/2023, right?
Yes, my lord.
Permission granted, specially petition, the contempt, specially contempt petition is dismissed, is withdrawn with liberty as stated above.
Deeply obliged. Deeply obliged for that.
Before I just from this report, 24th of February, matter was listed. I don't have any problem with listed here, madam. This honorable court, this matter was listed before the honorable court of Justice Pardiwala.
Why is it coming here?
I don't know, madam.
They have mentioned, my lord, it was gone to the Court of Justice, also party. So
whatever it is,
because they have mentioned that before any court, my lord, we have no difficulty. So they have been mentioning that it has to be listed early, therefore 3 times it is listed before different bench. That is that.
We have no problem.
We have no problem with any bench.
Here or anywhere.
We have no problem.
But they have mentioned now they are showing this order that this was listed before Justice Pardiwala. And he himself mentioned 3 times.
Actually,
Sector, we also find it difficult. What is to be done? Listed 2 p.m. top of the board.
Lord, it was on NMD, my lord. He mentioned 3 times there is urgency. There is no urgency in this matter.
There will have to be a little bit of hearing in this case.
It will take time, my lord.
And number one. Number two, my lord, I am for AMI. These people say,
before that you take
my writ is actually pending in the High Court. That may have to be called, but your lordship may commence the hearing. They have been very keen. I am not expecting any hearing.
So that's before another bench. They fixed a date for hearing and they put it up at 2 p.m. We'll take and we'll find out अपने पास क्यों आया है. Unless somebody is recused or anything, we'll find out.
It was
We'll find out.
Separate NMD
matters.
Find out, sir. We'll find out.
Institute is concerned. The AMI, my degrees beyond a particular date are not being recognized by the UGC. Now, the students and us.
But students, they have admitted.
Now, students.
So what is to be done about them?
Let me tell you now. Students and us both went to the High Court. Their writ gets decided earlier. My writ, which is the substantive writ, is still pending.
You are?
I am the AMI.
Oh, they are supporting.
Yes, here I will support his.
I am also, my lord.
Aeronautical engineering.
I am also, my lord.
Associate Institute of Mechanical Engineers. They are under a royal charter. There are judgments of the High Court also.
I know it's on the ring road.
Yes.
Next to Vikas Marg.
So either that writ will have to be withdrawn.
I know where it is.
So that my case is also heard, because otherwise I will be left out in the court. All the documents are there in that writ. So whenever
We'll just find out, Mr.
Yes.
Papalia. If we have to hear, we'll hear it.
Yes,
We'll
my
go
lord.
somewhere.
I am also, my lord, same. I think he supports our case. I'm the first matter in this.
My lord, this is an NMD matter, my lord. It was listed on non-miscellaneous date. It will take some time.
You'll find
This is the third round of litigation, my lord, on the same issue, my lord. It is squarely covered by.
This is an application for withdrawal.
Part 7, I am seeking to withdraw this petition.
dismissed as withdrawn.
For Tamil Nadu Pollution Control Board, my lord. Because this is a renewal application, my lord.
But I extended appearance on behalf of the board. If it's a simplicity withdrawal, my lord, I have no objection. But if it's a strategic withdrawal, my lord, I may have.
No strategy.
No, we-
Very well, my lord, then I may be permitted to withdraw it.
So dismissed as withdrawn. No, Mr. Yogeshwaran, land council seeks to withdraw the, is it an SLP? Specially petition,
Civil
permission
appeal.
granted?
Civil appeal.
Civil appeal, permission granted, appeal stands dismissed as withdrawn.
Please, my lord.
My lord, sorry, contempt.
My lord, till there is.
Ma'am, please, your lordship.
And
My lords, I request only
There
4
is
weeks
still
time. My
non-compliance,
instructions
my
are that it will be complied within 4 weeks, my lords. We have initiated the process.
Okay, Mr. Parth Avasti, learned counsel for the respondent submits that the directions in our decision dated so-and-so will be complied within a period of, within 4 weeks. From
4
today.
weeks, my lords.
Within 2 weeks?
4 weeks, 4 weeks, my lords.
4 weeks.
My lord, let it be 2 weeks only.
Doesn't matter.
Please.
We'll dispose it off, or you want us to?
My lord, may
suspend?
keep it pending, my lord.
List after 4 weeks. Then
Please, my lords.
My lords, I'm on behalf.
Here for the petition. My lord, the petition has become infructuous because the respondent has ended her term. My lord, I am seeking liberty that I may be given a liberty to approach the court again in case she is re-elected. And the question of law may be.
it stops you. So many imponderables. Okay.
My lord, may keep the question of law open.
In view of the statement of the learned counsel for the petitioner that the matter has infructuous, the specially petition is dismissed. Thank you.
Highly grateful. I don't.
Wait, please, my lords.
Letter.
Because there's a letter and a counter letter from us. Consent date was after mentioning. Otherwise, my matter will become infructuous.
So what?
Plans have been received. COC is considering the plans. The demand has been held to be illegal by the DRT. So there is no demand. Yet, so my only
Circulated
prayer to
letter
them-
vanished.
No, so I filed an
Jaiswal has
I'm sorry, Manoj.
balance sheets and other things. We'll examine it, whatever.
Not even, Manoj, even without the question of balance sheet, the demand has been held to be illegal.
Get your friend, we'll hear you.
Yes.
He's not there, what do we do?
No, no, it's my only.
Letter circulated.
No, and a cross letter. There's a cross letter sent to them. So, Manoj,
22nd.
at least status quo be maintained.
All right, we'll list you. Next.
Plus, may I only pray because there's an application.
Giving an early date.
Can it be, Manoj, next week? Because after mentioning, they're considering the plans. That's my urgency.
We'll give a date.
Next week, Manoj?
It's too tight next week. After that.
Well, I appear for the RP matters. My appearance may be recorded.
Yes, yes.
Great.
What do we say about that? I think that seems to be Mr. Vikas Singh.
I'll briefly explain.
No, because what we are saying is, we'll hear you.
So there is a set of clients who are to pay me 600 crore. And that 600 crore, the other set of clients says that I should have been actually not charged the 600.
For individual, how much it will work out to? Not really
No,
much.
600 crore, total is 600.
All total.
No, but
For
ultimately,
individuals will be
it will
entitled.
be the 600 crore which your lordships have to decide ultimately if I have to refund that money, that 600 crore. And now the difficulty because of a
Their
not full
case,
stay-
the
full
tribunal
stay-
has said that those two stand on completely different footing.
That's
Can't be a set off is what they have said.
Let me explain.
I think it's just
Result is, my lord, that these people, Mr. Sibal's clients are all around different period. Now, in one matter, your lordships have said, we can't equate, this is a different period, this is a different period. They want that set off to be happening here. Literally, they will be stop paying their bills also. They say,
There is no stay about refund.
So your lordships
We'll
have said,
vacate it.
your lordships have
We'll vacate it. Then what will happen?
No, I'm saying your lordships have fortunately already said that there is the commission may go on but not pass final order. But the commission is here saying this order can't be implemented.
No, what we are saying is that as an interim measure, the credit that they have got in the previous assessment year could be adjusted as
Yes,
against
that's all.
this, and the balance you can claim against them.
That's all
It's
difficulty.
a
I'll tell
simple
you.
arrangement.
That amount is yet to be quantified, number one.
Fine.
Now, number two, if it starts happening prior to my getting what I have to get from the other set of consumers, just see my predicament, Lord, I have also to run a business.
Today,
My
we are
appeals
called
were
upon
tagged
to
be
do
tagged.
because we are not hearing the merits of the matter. Today, we are called upon for an interim arrangement, right?
Interim
So whatever
arrangement is
endures to
already
the
there.
best interest of all the parties, we should make an order. We could make an order, or else perhaps you postpone your demand on them.
No coercive
Coercive
step, that's all.
step.
Please appreciate, there is no question of postponing. What is being demanded is the current bill. So there is no question of any current bill.
You work on it. What you do is, you take instruction.
Current bills we are paying.
We are of the view.
Current bills are being
we
paid.
can perhaps modify our order. We are inclined to, so that the credit that they have got, you will have to pay back. So instead of doing that, some kind of a sort of
Let them calculate,
and we have not completed. And this arrangement you make for a period of 3 months or 4 months or 5 months.
Let me explain, Lord. There are two appeals before the APTEL. Both were supposed to be heard together. My appeal was, when they heard the matter, their appeal was decided, mine was not decided. Now that is also judgment is, this arrangement can continue till that judgment is delivered, Lord. Because once that judgment comes, this problem will go completely. I have to take it
from them.
I have to take it from the discoms and
Then
pay.
till that point of time, don't take coercive steps.
No, there is no question of taking.
Received a notice.
No, they are the notices. I'll take instruction, not whether these are actual current bills or not.
Find out. See, we want all of you to just.
We will take I'm on the other
What we are-
civil appeal. I'm the respondent there. He's in the petitioners. I'm for the DBC in the respondent. I'll take 2 minutes on the solution. Well,
you
we
give
will
us
take
solution?
instructions. We'll take instructions. But your lordship should know that the 11th August 25 order under which he has to pay me in this matter alone of mine 68 crores. That order has been passed, A, following an earlier order of 17th January 25, which was affirmed by the Supreme Court. Number 2, in this order, impugned order, their counsel said we are only seeking extension of time to pay. It's recorded at page 6 and 7.
And now they say.
Number three. No,
Till the refund order is given.
no, the prayer is not till the refund. It is saying we seek extension and they say or in the alternative till the refund order is given. Now, Malas, the third thing.
Tell me, how long will the tribunal take now? I mean, there's hearing those
It is
matters.
reserved about 1 month back, Lord, more than 1 month.
Well, they were to finish it by 15th
After 3 weeks.
How will DVC recover this? Malas? How will
No, that order is already there, Lord.
No, there's a disconnection notice on
Okay, we will only say that there shall be no disconnection till the next date of hearing, till 3 months.
But
Yes.
Lord,
Yes.
what are the
They will never recover. They must deposit. Let them deposit in court.
current bill-
How will we recover, Malas?
What
How
is
will
the
we recover?
particular bill which they are not wanting?
Yes, we are all
We
paying.
don't even
We are
know
all
what they are
paying.
saying.
Should they not deposit in
Yeah,
court, Malas?
whether it's-
Let them not pay me. Malas, it's only, the order is 50%. Let them deposit in court. We will not, don't pay me, put it in court. How will we recover, Malas? It's DVC.
Which they are wanting
You are
to bring
trying
to
to
our
recover.
What we don't
We'll only say then.
Either they give it to us and we'll take instructions.
What is the expected time for the tribunal to complete 2 months?
Without your lordship direction, it won't happen.
It's reserved.
Lordships can
Judgment is
actually
reserved.
expect that.
It won't happen.
Your Lordship, no, because judgment is reserved, I think, about more than a month back.
Your lordship knows the,
Knows
In
what?
fact, your Lordships are grappling with this issue of
Lordship
orders being reserved and not being delivered.
we can express pious hopes, but lordship have to say something.
Okay, we
Your
will say
Lordship
that.
say so.
Mr. Sitesh,
Especially-
you are for whom? You tell us. No, how best to balance the interest till the judgment is delivered is what we are saying. There is a credit and there is a debit.
Yes.
So there can be a set off is what we thought.
Large consumers who have been treated as consumers are being, the actual result are licensees and they cannot be included in the body of consumers. Now if that is the judgment that is awaited, if they are indeed to be included in the body of consumers.
We have nothing to do
then
with
there
it.
is nothing to do with the actual judgment.
The multiple claims. Multiple.
So that the financial adjustment.
How many of you are there?
We are 16 of us.
Many of them are paying also.
Well, 13 of us. We are 13 of us.
It create a
13 of us.
The moment your Lordship pass an order, everybody will stop.
Kind of much.
That's the difficulty.
Financial adjustment will depend.
You make a statement and bring us. You show us
Very well. Let me take
comparatively.
instruction.
You make till that time, 1 minute, you make a statement, we will balance the interest till that time. Don't take coercive.
Provided current dues are, current bills are paid. Of course. No disconnection, my lord, because I have received a disconnection on
It's
10th
not my statement, no disconnection. Don't say anything.
let the
Call it out.
commission-
Don't say anything. We are saying no disconnection
second.
till Lordship next date. We'll give a
Right.
statement.
Good enough.
And one of the things is going to be, should they deposit here, not to me, otherwise I can't recover. These 16 people.
They are going away to different lot.
We will, whether to deposit or not, we will take into account also, and we will hear all of you about the, may not be a direct set off in the sense of what is to their credit and how it should inure to their benefit only till the final decision.
Well, but let them decide within 2 months, 3 months.
Come back to us.
Letter they are writing.
Commission has to decide the.
Come back to us. Come back.
Now, may I say something? Commission is directed to decide the extent of the, will you allow me, please? Will you allow me, sir? Commission is to decide the extent of the credit to be given to the 13. Commission has not decided, Millet, since December.
How do we give a set off to you?
I'm sorry?
How do we give a set off to you?
No, therefore direct them to decide it quickly. That's all, so that we know what the credit is. That's all, Millet.
So they are actually groping still in the dark. They want us to stay without even going, what refund is up to them.
They don't want to decide.
Okay, Dr. Singh, what we will do is, we have not record your statement if you want.
Yeah, it's clear.
Everybody is
It's till the next
We've
day.
heard loud and clear that you are not going to take any coercive.
No,
steps.
no.
You come back with
A
suggestion
statement, a chart.
and in consultation with the commission also, how to best protect the interests of both the parties till the final decision is arrived. Then
And
we will
Lord, one more thing, Lord, your lordships are oral undertaking. They should also be paying the current bills. I don't want.
Correct, of course they're going to pay.
Let that also be part of the oral
We will
undertaking.
say that.
Our enterprises, they are ongoing. It's a steel manufacturing. Because the statement would.
No, these units are going away to a different.
That's one thing, Lordship, know the facts and reality. What they don't teach in law, one thing, they are asking others and themselves shifting to other licensees. That's why I said you can't look at the
We
letter.
have to go for civil suits.
How
We have to go for civil suits to recover our dues.
Those are-
Any indulgence granted by your lordship.
The order is enough.
Don't take. Listen.
They are writing letters.
Those are again, disruptive issues in the sense that we will not be able to resolve. You take action against them if they sell it to third parties. There's no doubt about it. But so far as the present is concerned, pending dismissal agreement.
May I say something,
Dr.
Lord?
Singhvi, is going to, is requested, submits that a statement indicating liability and also the credit as obtained between DVC and its consumers will be submitted in 2 weeks from today, in a week's time. In a week's time from today. In the meanwhile, we make it clear that the respondent, that the companies will continue to pay the current dues
not switch
without fail, full stop. In the meanwhile, they shall not, the DVC shall not take coercive steps.
No, they should not switch licenses. But what they do with a large due, they will go over to someone else and then my only recourse is to civil suit.
To take action against them.
No, I can't, Lord, if you want to.
That's not an issue before us.
Lord, there is a complete freedom to choose your license.
Between now and then, they should also not switch, Bharat. How can they switch?
Licensee, I will have to then go for a civil
Bharat,
suit.
with a 68 crores against, with a 68 crore against me, how can they switch, Bharat? It's like saying you run up in one shop, 68 crore dues, then go to another shop.
Make that
Can't, that's not fair, Bharat. That's not fair.
Make it clear.
Not necessary. Not necessary.
May I say something?
Then we are putting it up only after 2 weeks, that's all.
Yes, ask them to direct
In
them
2
to
weeks, list this matter, get the statement, we will pass an order.
The commission to
List
decide
this
on the
case.
extent of the credit, but that must direct the commission.
Okay, in the meanwhile, we also direct the commission to give a, to provide the correct figure on the basis of which orders could be passed.
May I say something, Lord?
That aspect is the actual is now saying go back to 2009 and segregate all the distribution aspects from the transaction and do their attribute their costs. Lord, that is not possible.
So what do you want us to, what are you?
In fact, we conflict the after loan order.
And Supreme Court judgment.
That's an argument.
Point in the appeal.
That is an argument at the merits of the matter. What are we to do today?
No, that's a separate issue. What he's saying is a separate issue.
consumer effect of two of these large entities not being consumers, I can work out as this. The effect of transmission, distribution, assets being segregated is almost impossible to do. There can be some financial adjustment which has to be done by the CRC.
That's an argument. What do you want?
The direction is combined, the computation based on.
He has not challenged that order, Madam.
Anyway, you get this statement, we will pass a comprehensive order. We'll pass a comprehensive order to whatever it's.
After 2 weeks, sometime.
After 2 weeks.
On the computation of the review for that.
To help them, sir.
2 weeks now.
All that we needed to do today is to pass some kind of an order which will ensure protect the interests of all the parties and nothing more, nothing more. So therefore, when that burden, don't put the burden on us, just try and work it out.
Not appealed against that.
You pass that order for. No
Milord,
words.
51.2, Milord, there are 3 consumers, Milord. Milord, I have already paid, Milord, 15.70 crores, Milord.
He said no.
What I want is the adjustment, Milord, in the.
We said no coercive steps, sir.
No course.
The only thing is, Milord, I was praying that I have already paid, Milord,
All right,
it will be adjusted, Milord, in the subsequent bills, Milord.
Right. Mr. Vikas, anything more?
Let it be brought in immediately after this second holiday.
Not that I should say so, Mother. There must be some order in the turn that we speak, mothers. There must be some order.
Both of us are here.
No high courts, mothers, allow this to happen. Anybody speaks at any time, mother.
Used by other.
That's all right, but one by one, whatever you argue, please argue, but allow people to speak.
That
Not
burden is
intervene
always
in
on the
discussion.
court.
This is not
That
fair.
burden is not always on the court.
Don't know
Right,
what's
so
happening to this.
It's not very
highest court of
difficult,
this
isn't it,
country.
Mr. Dr. Singhvi?
Most unfortunate.
It's not very difficult to.
Only way is, well,
It's a matter of culture, that's all.
Before
only
the
way
matter
is if your
starts,
lordship
people
says
will
after
preempt.
2 or 3 minutes,
They will
stop
say-
and ask the name of the next council.
Let give me
That's the only
2
way it will work.
minutes. Give me
Otherwise,
2
nobody is going
minutes
to.
before he
the
says
lordship
something.
gives the 3 minutes,
Then it's
stops
gonna
him and
go
then
on
asks
like
the
that.
But
Can't take the name.
Full argument. This
Allow us to argue.
Ask them questions even before.
That's right.
That's the
That, in
Because
fact,
what happens
right-
is, well, sometimes the petitioner argues so long that the respondent
No, what
is
you-
inclined
you are
to
absolutely
intervene
right.
because, well, your lordship's mind is made up there according to us.
You are
We
right.
may not be right, but your lordship's mind.
But my learned friend is so succinct, mother, that he doesn't
We
need
have
to
been-
argue at all, mother.
On so many.
We are not as
aspects of-
succinct as he is, mother.
On so many aspects, no, we are just sharing our thoughts.
Dr. Singhvi, of course, never takes any time at all. mother.
Yeah, your sarcasm.
No time at all.
Sarcasm will not help a solution.
If we are able to finish our
No,
argument and then call this problem.
We have been experimenting on various things to introduce. It's a kind of a culture that we all have to evolve,
Lordship calls.
evolve and do it. Perhaps there is a need of leadership and there is a need for
No, we are ready.
enforcement.
We
We will have
Only
to.
thing is not in a matter like
We
this.
have the best of the bar, so therefore I think it's a simple
No, I
method by which we
In a
follow.
matter like this. if-
And Mr. Vikas Singh, at the same time, it's not as if you are unconnected. The bar is not unconnected to it. How many times did the bar or the president call for a meeting and say that why is it that we are conducting in this manner? Let us follow one system. Where did it ever happen? We're not saying anything. We are just saying that from that side also, I think some kind of a thing that you need to do to follow a discipline.
Lordships have been in this court from the beginning. I've also been in this court not from the beginning. The way, Lord, your Lordships decide, especially on interim issues, we can't, Lord, if we are not given the full opportunity to give our case before your Lordships call upon
We know,
them,
we know.
that's the problem. Right?
And also, the Supreme Court is unique in the sense that these decisions are taken in split seconds.
That's right.
And you have 21 councils, each one
That is
putting forth their contention, and judge suddenly takes a decision and calls and says, call the next case. Where do we go?
And that probably your Lordships can't change.
We know. Because the pressure of work, nothing more than that. We'll work it out, we'll work on this. We're sure we'll be able to work on it. It's not not an unsurmountable issue.
Practical solution is only one, Malas. Your lordship, when you think that you have got the point from me, takes his name. When your lordship thinks your lordship got the point from him, take the other side's name. That's the only way. And then, Malas, once the name is called out, then there is no question of me continuing. Provided lordship, your lordship has to regulate it.
Despite we calling everybody talks, that's the.
No, Malas, once your lordship says now, we have heard you, now the next. But otherwise, by itself, it won't happen. It won't happen by itself.
You are right.
Your lordship has to regulate.
It's happening in every
Not
court now.
petition, then at least one should be given the opportunity to complete.
Let's just reflect on what
appreciate
from your side also call
I'm
the,
facing
this is a
this-
collaborative thing that you must do with in fact, more than anybody. It's the Advocate on Record Association. Who is the master really speaking? And all seniors owe it to AORs.
Not really, Lord.
Of course,
Senior
of course.
after
I mean,
the
if
briefing,
the AOR says that, sir, you are, you just
what
say
the
very
senior does
seriously,
standing here has got nothing to do with
says
it.
that he controls.
So he controls only the briefing.
that's
But
what-
once the senior stands, Lord, there is no control of the OR remaining.
They
So the
should.
senior has to take it on from there.
Look at the other courts.
With the leave of
But we've seen.
Coming back to the point.
spoken minutes, I wanted to point this out. Why? Because item 51.1 is one petitioner who's asking a stay on the demand. While he's asking for a stay on the demand before this honorable court, he's writing to my competing licensing wanting to switch.
Same
So
breath.
this is money that he owes me. He's going to pay without paying this notice.
Okay,
But that's not the dispute
we
here.
heard, we heard. We heard and we are not passing anything. We heard it, that's all.
That's all.
Very well.
So we'll give you a date. Come back immediately.
Could it be a Tuesday, Lord? Because otherwise it doesn't get.
14th. Is that all right? Or 21st?
Whatever.
21st.
21st. Deeply obliged. It's a Tuesday.
Tuesday.
Deeply obliged.
Lord, 52 I appear for the petitioner. Now 3 dates I'll. 52.1 my lords. 52.
32.
In this case, this institution is running B Farm and D Farm courses since long, 2003.
So what are
and
we to do?
2009.
They have permitted you for the next year?
Now, as far as 25-26 is concerned, Pharmacy Council gives me approval, this approval for new course, that is M-Pharm course on 30th September 25 for 25-26.
What do you want today?
Now, thereafter, my lords, the university conducts inspection for grant of affiliation. The inspection report is in my favor. They send the report to the state government. State government says, yes, you grant approval.
But did you ever have M-Pharm?
M-Pharm is a new course.
So you never had M-Pharm?
I got approval last year for 25-26. Now the inspection report of the affiliating university is in my favor. But they say that since the last date fixed by your lordship, that is 15 November was over, so we cannot give. And they say
You cannot give what? You cannot?
We can, since the last date fixed by this honorable court, that is 15th November was over, and the state approval comes after that date.
1 minute, that relatable to 2025-26 is it?
Yes, my lords.
That's gone, sir.
No, I'm not asking. Your lordship made it clear on the first date when issued.
26-27.
Yes. Now the Pharmacy Council's approval is there.
26-27 application last date is when? Was when?
That is over, my lords.
That's also over.
Yes.
Today you want your case to be considered for 25-26.
26-27.
26-27.
That was made clear by your lordship.
Anyway, 26-27 ko, so I think you.
I'm opposing, my lord, being the council, my lord, pharmacy council.
What would have been the last date for application for 26-27?
I have submitted application in first case.
In first case, application is pending, my lord. In second case, they has not filed the application.
Why have you not filed?
The reason is, I'll come to that, lords. The reason is, kindly have, my lords, the order passed by High Court. Kindly have, my lords, in the second matter, page 210. They give me, my lords, approval on 5th of November 2025.
Hey, what do you say? What do you say about this 25? The other matter, first matter, there is no difficulty.
No, my lord.
They have already applied.
Yes, yes. It is under consideration.
Which are the other matters apart from?
Lords, in second item, in the second matter, for the purpose of submitting application for 26-27, I went to High Court. High Court directed them to open the portal. They have till date not opened the portal.
No, my lord, it's wrong.
So, 1 minute. That is also, second matter also is relating to you wanting to start M-Pharma for the first time.
M-Pharm and Pharm D courses, 2 courses.
For the first time.
For the first time. I got approved, my lords, approval from the Pharmacy Council.
Okay, you are appearing for council.
Yes, my lord.
And what about him?
He's for AKTU, my lord, university.
I am for the
University. But I think you should permit his take this application.
My lord may direct them to file the application within a week. We will consider, no issue, my lord.
That's it. Okay.
Yes.
Okay. Why you?
Once they give approval, our role will come. We are at the second stage.
Within a week's time, you make your application.
We are ready to open the portal.
No, in the second, first anyway, it's there.
First is under consideration, my lord. We will grant.
What I am requesting,
what I'm asking, what is your agenda?
No, agenda is very plain. It's very plain. In 25-26, Pharmacy Council gives me approval well within time. That is
25-26 is over, sir.
No, I'm not. Same thing will be repeated now.
Now 30th September 2025, I get approval for 25-26 by Pharmacy Council. Now sufficient time was available for the university to consider my case for grant of affiliation. That was 15th November. Now they delay the matter.
So what do you want? You want damages or what? Now we are permitting you.
What I am requesting is the same, my lord's approval as your lordship granted in earlier years, 22, 20.
Approval?
No, they may consider, because I have not started the course, my lord. They will, now Pharmacy Council will give me.
So I think his problem is that even assuming for 26, 27, his application is taken.
Yes.
And that the process of checking up and all that will take place.
Yes.
And you might not be able to permit him for 26, 27, and in the meanwhile classes will start. Is that?
No, no, no.
Yes,
He
yes,
doesn't
that's-
want to lose 26, 27.
Cut off is the 30th of April, my lord, for this session, my lord, 26, 27.
30th of April.
My lord may direct to consider this application on or before 30th of April.
Granted me approval well before the cutoff date last year.
Direct
The university,
You want that to come into.
no, university delayed the matter and said now cutoff date is over. So I suffer because of the statutory authority.
That's where we will decide it
They
before
will
30.
decide within a time, your lordships.
Yes.
We will decide within a time.
That's
When you
all.
get lords, if
In
they-
first order, first one, we don't need any, no orders need to be
Yes,
passed in the first case.
My lords, in the
First
first,
case, no need for any orders. In the second case,
no, my lords, may I?
okay, we will say that application has already been, it's for affiliation, isn't it? What is it?
Approval.
Approval, my lords.
Application for approval, first में, दोनों common order कर देना. Application for approval is already filed, which shall be taken up and
Consider
disposed
and
of.
decided on or before 30th of April 2026.
September 2026. In the second,
My lords,
in the second matter,
in first matter, direction to university also. They have to decide, because last year
the
they didn't
council
decide.
and the
it like-
university take decision before 31st of April.
Plus 30th April, they will do, plus thereafter your lordships
15
will
days.
fix the cutoff date for deciding affiliations. Your lordships may.
You shall take a decision, council shall take a decision by 30th of April 2026. Thereafter, the university shall take its decision within 3 weeks from there. 3 weeks
Okay.
thereafter. In second matter में बोलना, the petitioners shall make an application within a week from today.
They will open the portal.
For which reason the portal shall be opened for receiving the said application. The said application shall also be considered by the council within 30th of April 2026, and the university shall thereafter pass necessary orders within 2 weeks thereafter. Right?
Plus 3 weeks your lordships will give.
3 weeks
in
कर
both.
लेना दोनों में, ठीक है?
Oblige.
Please, so great.
With these directions, both the matters are disposed.
May I suggest one
So great.
thing, Lutz? Otherwise, there will be flood of new petitions coming after this order because your
So season is starting.
that
Season is starting and he has to be on this
So,
side.
I don't know, Lord, whether.
new crop.
Lord, your lordships have said 1 week to open the portal.
Uh-huh.
If anybody has missed, they should open the portal for everybody who could not apply.
No, no,
No, no, it is a
No, no.
related state. It is a case where the matter is pending.
Do that.
Otherwise, everybody will come before
No.
your lordships based on this.
No, no, no.
That will be a danger. That will spoil
I
the
know
whole
that.
schedule.
This order is not to be treated as a precedent.
Yes.
This order is
good.
not to be treated as a precedent.
Oblige.
So grateful, so great.
ये तो कुछ नहीं है सर.
May it please, my lords. My lords, I am appearing on behalf of the respondents. We have filed our counter, though it's
Right,
not
first
a record.
refusal.
My lords, this is a auction.
I am
matter.
seeking some time to file rejoinder, madam.
My lords, I'm just saying that it can be listed little early.
Well, I appear for respondent number 5. My bid is 30,000 higher. What the High Court, the single judge, as well as the division bench says is that the first right of refusal only comes into question when the bids are equal. But my bid is obviously higher. So where's the question of being
It's right. When the bids are equal,
bids are
the
not
higher price will come
Your
only when
lordship
the
may
bids are
grant
equal.
1 week time, my lord. The other side has filed a counter, my lord. Your lordship may grant 1 week time, my lord. I will come to that.
Nothing is happening on.
That is
strength
not,
of your
that
case.
is, that is not correct, but I will say.
no stay, but I'm still.
Lost from all court.
We will ask.
1 week time, your lordship may grant 1 week time for only, my lord. I am not asking more.
What is
Because the
happening
state
now?
has filed
You
counter.
started.
But I've not been given possession.
We have not granted any stay.
That's
Is there a stay?
My lord, may
No, no.
India, there is-
There is no stay.
There is no stay.
No, we have not granted any stay. You can go
They
ahead.
have filed counter, my lord. Just I am seeking only 1 week time,
Next
not more than that.
Next week.
Yes, my lord.
Final hearing, my lords, will dictate.
We are still at the admission stage. He has not fully convinced us. I hope he will convince next
Yes,
time.
my lord. My lord, there is a clear cut.
Come back.
Lord, may I have it on a miscellaneous bail?
All right. Very good.
Please, my lord.
Suggestion.
Lordship, in this matter, the tender has been called off, has been cancelled.
Oh, is it? I'm sorry, we didn't know about this. But my lord, we are challenging the condition.
Tender has been cancelled.
They've just filed that reply.
Tender is cancelled. It's infructuous.
Lord, in that case, my lord, if in the new tender they reintroduce that, I should have the liberty of then.
Whatever it is. Why don't you have? This matter has become infructuous in view of the statement of the Learned Counsel for the
question.
Respondent, DG.
Delhi Jal Board that the tender has been cancelled. Okay.
All questions
All questions of law and fact are kept open. What were kept open for what? All kept open. Okay.
Otherwise, I'll be bound by the High Court.
That's
Lord,
right.
that's a problem.
Kept open. Right.
Obliged.
May it please, Your Lordship.
Kanchi,
Your Lordship, before the Learned Council starts, I wish to state I filed a reply for the respondents in this matter. The reply is unfortunately under scrutiny or maybe a defect has been marked today in the morning. My lord, I'm willing to, if the my lord wishes to decide the matter, we are willing to.
file a rejoinder. Counter.
I filed a counter reply.
Not on record.
It's not yet on record, my lord. In the morning, we have served
Okay,
it.
bring it on record. Bring it on. Let the counter affidavit be brought on record.
My lord may give us 1 week time. We'll file.
We will have to dispose of this matter.
Okay.
It's a foreign decree. We shouldn't be keeping it for long.
My lord, in fact, we are willing to argue the matter. I have the annexures printed, but
Okay, you bring it. You bring it.
indeed, I'll do that.
Can we put this in?
Put it up on Tuesday. Then just check that up. Take that counter.
Yeah.
Take it up, whatever it is.
We've
there.
also raised an objection on their Wakalatnama because now there's a judgment of our court which says that as far as the AOR is concerned, if it has been notarized, say, overseas, if it has been affirmed overseas and not in the presence of the AOR, then it has to be suitably notarized in that jurisdiction and thereafter endorsed. So we have informed them about that.
My lord, they've raised the objection due to the war situation. This is a matter pertaining to Dubai. There was a slight delay. We'll
Anyway,
clear
whatever
up
it is,
all the
no problem.
objections by next week.
Why don't we give this? Would your lordship, would you permit us to file written short note of submission? Then your lordship can go through that and then we'll.
Why not? Why not?
My lord, copy
Yes,
may
I'm
be supplied
grateful.
to us as well.
No, we'll give it to them. And
Both of you file it.
my learned friend wants.
Prepared a written note.
My lord, not yet. Since my counter wasn't.
Do one thing. Take their written note.
Yes, yes.
You prepare yours.
Yes.
Indeed, my lord.
And then ask them also common orders, which both of you would be referring. Make a compilation, submit to the court.
Absolutely.
All right. All right. No problem. And my learned friend
do you
wants to file a rejoinder. So would you give us a week and then you may place it
I
up?
thought you are in an urgency. Okay. Rejoinder in the meanwhile. Let the counter affidavit be taken on record. In the meanwhile, 2 weeks time for filing a rejoinder. A list which date they there.
On the last occasion, my lords, your lordships had directed them, they had given an undertaking not to execute the award. That
Not
we
to
can't-
precipitate, yeah.
Right.
Very
grateful.
So it's not recorded in the order, so.
No, it will be recorded.
Parties are here.
Party shall maintain status quo till the
Status
next date of
very
hearing. Mr. Diwan, we are passing a status quo.
Yes, I'm grateful.
There should not be an uncertainty.
Very
Yes.
grateful, my lords.
Bless.
Allow my permission for a Passover. My lord, in this matter, I need a Passover. In this matter,
High Court,
What remains in this matter?
what password?
my lord, the senior is a.
My lord.
Tell us. He is here. Yes, Mr. Chitle.
My lord, I'm appearing for the caveat respondent.
Okay. Then you tell us.
Passover, my lords. His legs are in other court.
My lord, all three courts have held, my lord, in my favor.
Tomorrow, come tomorrow. Next.
Deeply.
This is the case.
I am not.
I am a corporate guarantor.
Section 7 was rejected in my favor. One of those rare cases, my lord, where 7 is rejected. Now, my lord, in appeal, the NCLAT sends it back on a remand, but virtually, my lord, negating the order. So the remand will now be, my lord, a formality. That's why I have come in appeal.
Negating means what?
Negating, my lord, the reasoning of NCLT, which was in my favor. So the remand, my lord, will really now not be of any consequence, because now the order will fall. That's why I have come in appeal. And I want, my lord, only 2 or 3 facts I want to give you. Very important. Because I am a corporate guarantor. So there is a principal debtor, very broadly I'll tell.
What's the difficulty in raising these questions before the NCLT at all?
You know, I had
succeeded.
I had succeeded that the suit is dismissed. My lord, it is now remanded with these observations. My lord,
show us those observations.
Yeah.
What's
But let me give you 3 facts first.
What is troubling you in the remand order?
My lord, just note 2, 3 facts, my lord. Then your lordship will appreciate. Just 2 or 3 facts, not more. My lord, I am a corporate guarantor. I am not a debtor. There is a debtor who took, my lord, a loan from ICICI Bank. So the debtor, my lord.
Principal debtor.
Yeah, principal debtor. Principal debtor took a loan from ICICI. And principal debtor, my lord, pledged some shares, my lord, as security for the debt. That is between the principal debtor and, my lord, the creditor. And I am a corporate guarantor for additional whatever. So, my lord, those shares at the time when the pledge was created by the borrower, the shares were worth 600 crores. That is a report of IDBI, because no bank will give a loan, my lord, of some 700 or 500 crores.
They are still there.
Unless,
why go against? So why go against me is your point.
No, not that. Not that directly. My lord, I am saying you can file in a given situation. Now they say, my lord, that they have appropriated those shares worth 600 crores for 48 crores. In 15 days, they've appropriated. So they say, no, now 500 is due. And therefore, my lord, after 2 years, all this has happened.
That means you are talking about ICICI.
Yes. So they have, my lord, appropriated value of the pledged security of 600 crores in 48.
What the point?
Now this part went to, my lord, Surface and DRT, because those proceedings going on. That led to the High Court. The High Court said the main bone of contention is the valuation on the day when it is given and when you have included. The High Court remanded the matter back, my lord, to the DRT, etc. That is now going on for purposes of that valuation.
That branch is pending.
A branch is pending. Because of that branch, NCLT said, my lord, that section 7 today, after 2 years, is, my lord, premature. You let the branch be done. That branch will determine, my lord, if it was 600, then you are home and dry. That is 200. That is 200. Yes. If 600 you get, my lord, or appropriation showing 48, then on 600 you are home and dry, then you can't file. This is, my lord, the background.
The larger perspective, it stands to reason.
That's what I'm explaining.
To broadly resolve everything.
And if that is, not, if they were genuine, they would have filed it on day 1. After all that is going on, they waited for 3 years and then filed a 7.
You have given a macro picture, that's correct.
Yeah.
But then how do we resolve this micro issue?
So simple was,
Micro issue.
Micro was wait for that.
A remand order.
No, my lord, that they should wait for their branch of the High Court. If that comes and
ask NCLT to wait.
Yeah, that's what NCLT said. Okay, it is premature. You can come again. It's not just a limitation is running away. And liberty is given to come again, my lord. I'm waiting for that branch to end.
So
when that valuation, etc. That's how, my lord, has happened.
For stay of NCLT.
How can one more point?
Can't be done.
Your lordships have held, my lord, that NCLT has a summary jurisdiction. It's only concerned with debt and due. It cannot go in.
What stage are they before High Court remanded and DRT proceedings are pending, is it?
They're pending.
But then the implications of that may not be directly on the section 7.
The CIR
there are multiple issues so far as 7 is concerned.
If the CIR were to go on, and tomorrow,
what will happen is, my lord, moratorium will kick in. If moratorium kicks in, if the petition is admitted, as it is no, then, my lord, the remand of that branch will also come to a freeze.
Correct.
That also can't then go on. So this is a tangle, my lord, which has happened. That's why I mean, appeal, it has, your lordship should.
And if the valuation were to be held to more than 200 crores, what is here can't be unscrambled back.
Too many management. We just ask them, how do you?
And NCLT, my lord, can't do the valuation which is pending in that branch.
We will ask them.
Yeah.
Yes.
Yes. Now, Manoj, I mean, but for the fact that it was canvassed seriously, I would have started laughing at this submission. Let's just note one thing. Those shares fetched absolutely zero. Just please note that amount. What he's talking about in terms of the pledge is with a third party. There are multiple security. The company of which those shares was given was Carvey Data Management Services Limited. That went under CIRP. There is a new management in that. So ICICI realized nothing from those pledged shares at all. Now this is a completely independent proceeding. It's against the party. Sorry.
What kind of this company?
It's the corporate. It's a CD. This is the corporate debtor under a corporate guarantee. He's an independent corporate guarantor, and he has to.
How much is the claim?
The claim today would be, Manoj, the claim in my section.
You are the common creditor in DRT as well as the High Court and those matters.
Sorry?
And as well as here.
Yes, as well as here, because he gave a corporate guarantee. So those were earlier DRT proceedings, which has my friend said. But these
Let's
are.
have a look at the impugned order. Let's look at the.
Yes, please see the impugned order. So Manoj, I'll just answer your question. My section 7 application mentions 199.63 crores. Today, the amount due is 467.08 crores as of 31st December.
Overnight, we know about.
Sorry. Now, please see the order.
Those amounts we know about how they increase.
Yes. Now, please just see para 3.
There are only two. Yes.
May I take you to para 3? Primarily, the ground taken by the learned tribunal for closing the company petition while reserving the rights of the appellant to revive back the proceedings of the.
Is it a solvent company?
This company is solvent. I presume they should pay us. They should pay us this amount.
No, why we are asking here? You can't just push companies after companies into CIRP and then put an end to this.
No, but
what happened? 7 starts means that's.
He's a corporate debtor.
The RP will take over the company.
But it has to happen.
Is it a solvent company?
No, solvent in the sense he's not paying his solvent provided he pays the due. Mine is a modest due. I told you it's 199 crores and he gave a corporate guarantee.
Okay,
in an
let us
IBC
see
process.
some observations if they are there, we will remove.
Yes, Your Lordship may remove any observation. Your Lordship. Yes, I'll place.
1 minute, Mr. Diwan, we'll come back to you. Just
yes, any observation?
Just what's troubling you in the High Court's order?
Yes.
In the NCLAT's order.
So, first is paragraph 2 at page 2. This is the NCLT's order. Just see that, Milord. Page 2, para 2. The petition was rejected by saying
that you skip. Then
yes.
Then
Milord,
while remanding it back,
yes.
Is there anything when you have been foreclosed from contesting? Is there anything you want to tell us?
Kindly see, Milord, paragraph 8.
Only 2 issues which require
yes.
Paragraph 5.
Right. Whether it should have been closed as premature, etc. Now see para 8, Milord. In that eventuality, mere pendency of DRT cannot be a reason for closure of 7. First, there has to be a specific direction for determining value of shares by the High Court, and further it's an issue to be exclusively decided by DRT in the OA, which are pending before it. The directions given therein for deciding the interlocutory applications referred to in para 6 of the judgment cannot be taken as the basis for not proceeding. That's the whole question. Now you are talking about today, the day, my lord, when you took a valuation of 600, it was 600 then.
He is right. He is not wrong about it. Then,
my lord, paragraph 10.
In fact, the perusal.
And in fact, the perusal of the order which is under challenge will reveal that the company petition has not been touched and decided on merits. It is rejected with simplicity with the right reserved to reopen the issue after determination, which is an issue artificially. How is it artificial? That's the only issue, my lord. You had, my lord, shares for 600 crores. How could you appropriate it for 48 and now say it's 0? It may be 0 today, but on the day it was created in 2019, it was 600.
Whatever fair objections you will have about the maintainability of 7, you will be entitled.
Yes, over there.
That you can take.
But this was, my lord, this is the, now to say that those pendency, my lord, is of no consequence. What else will happen?
In convincing them.
Only one line. Their written argument.
Pending, but then
their written argument at page 361. Only one page.
Whatever section 7.
But only one page, page 361, what they contain before NCLT. Lordships may kindly have page 361 only for a minute. Para T. They say NCLT cannot adjudicate this issue.
361. How we say that?
Page
Well,
360.
if you understand.
That is their argument.
We'll give you that some leeway. We will say, third, Mr. Muthu Rohatki, Niranjan Reddy for the opponent, Mr. Shah Khan for the respondent. Having considered the matter, we are of the opinion that the order of remand does not warrant interference. However, it is made clear that the petitioner will be entitled to raise jurisdictional as well as such arguments as may be permissible for not exercising the discretion under section 7.
All right, very good.
Under section 7. Great. So we may argue that.
My lord, this is an application in Ashish Ranjan for the approval of time schedule for the academic year 26-27. Sorry, 25-26, my lord. My lord has passed similar order on at page 12. My lord, may kindly see this for the last year, my lord.
But item 63 is also on similar issue. But
Yes,
it could
same
take us
order.
up along with 63.
Same order. Thank you.
So, my lord, may kindly approve the time schedule my lord, as per the prayer. My lord.
What happened? Sorry, I missed the point.
My lord,
Item?
for the
We are
approval of
seeking modification of NEET
Ah.
My lord has passed a similar order for the last year at page 12. We want similar order for the academic year 25-26.
Other hand, who is for the petitioner?
My lord, petition.
Is it your application?
PIL petitioner because of the directions of this honorable.
Show us that order, please.
Yes, my lord, may kindly see page 12, my lord.
देखा ना?
Hmm.
58.
This is for,
This is-
this is permission for the academic year 24-25, my lord.
Is this your application?
This is our application. I'm so sorry. I thought.
Page.
My lord, I'll just show, my lord, page 24, my lord, may you first kindly see. This is the schedule for PG counseling, my lord. According to which, my lord, the last date was 31st of January, my lord. There was few seats were lying vacant, my lord. The time was extended at page 25, may kindly see. The last, my lord, column 4, my lord. The last date was 28th February 26. My lord, the process has ended, my lord. So we want an approval of this schedule, my lord. For the prayer is there, my lord. Prayer is at page 8.
Page 8. Application on behalf of the National Medical Commission.
Yes.
Is taken up. Just IN number the 1 minute. The National Medical Commission filed an interlocutory application for extension of the last date of admission in the postgraduate medical course in terms of this course order dated 28th February 2026. Full stop. Application is allowed and the time schedule, you want to follow this?
My lord, it has been done, my lord.
It's notified also.
Approval of the last date, my lord.
The
28th February.
28th February.
Fine.
No, today the new schedule will be this at page 25.
25, my lord. That was the cutoff date, my lord. Schedule because, my lord, may kindly see it was first round.
No, extended date that you are proposing is what we are asking this.
The last date is, my lord, that it is at page 5, the 25, my lord, 28th February, the cutoff date.
28th February.
After 5 matters, we may be asking for slightly longer extension in respect of some colleges. So that this, so that this is not put against us, madam.
That's not here. Your application is not here.
Today is there, item 63 today.
60?
This is an approval sought up till 28th February.
3.1, my lord.
Have you been served?
My lord, in item 6.
All India Council.
I'll wait. I will wait for 63.
You have said February. You have said 28th February. From 28th February, you have sought extension till when?
My lord, 28th February admissions were over. Okay. So we that approval of that date, my lord.
I'm not objecting.
Application is allowed.
Asking for further extension
is allowed.
I'm with you.
Yes. Then what is your application?
Lord, mine is a case.
It is.
I mean, it's 63. I'll make myself.
Just wait for a while. What is this?
My lord, I am a student preparing for government job.
The petitioner hearing challenge the answer sheet of one of the candidate.
Petition.
Who has obtained the answer sheet
32.
by means
Why-
of PPSC.
Article 32.
Go to the High Court.
Why have you come under Article 32, sir?
Yeah, my lord. Sorry, my lord.
Why have you come under Article 32?
Sir, I have security threat in Patna, my lord.
That's not, that can't be done.
Someone is calling me and threaten me.
You can file it.
Para number,
File a petition.
my lord, para, please see para, annexure P9, page 47.
Can't be done, sir. You go to the High Court. You go to the High Court. You withdraw this and go to the High Court. The petitioner is permitted to withdraw the petition under Article 32 of the Constitution.
My lord, please chance 1 minute, my lord. Please see annexure number P9, my lord, and page number 47.
Normally, we don't entertain a 32 petitions like this, and particularly in the facts of this kind of a cases. You approach the High Court. We have given you the liberty. You have not dismissed your case. You have not dismissed your case. You can go to the High Court. Okay? The petitioner is permitted to withdraw the petition.
But I have a
Article 32 to approach the High Court.
My lord, please, I have a security threat, Patna, my lord.
No, that can't be. That can't be. See. Next.
Item 60.
Yep. So I am a defendant in the suit for a claim of 1.99 crores. Principal amount is 1.8. 5 flats of mine, Milos, which are valued at 6 crores have been attached. Milos, Lordship will just have how the orders are passed by the trial court, Milos. It's an order 38 rule 5 attachment prior to judgment. So it's attached.
Attach the points and interim.
So I'm willing to offer 1 flat, Milos. I have no difficulty with 1 flat, but all 5 flats are attached, Milos.
To see what has happened.
Maybe a little excessive, right?
My lords, but what has happened is that one, they were given an opportunity. My lord will see page 70. They have not challenged that substantive order, which is what the High Court has found, my lords. They were given, my lords, an opportunity. Prima facie case was found. Thereafter, they were given an opportunity to.
4 flats, is it?
5 flats, Milos.
But
And so far as you are concerned, what is your
Milos, total claim is
1 crore 92 lakhs, my
what's the
lord.
cost of a flat?
My lord, that's what they are saying. It's 8,000 rupees per square feet, which is not justified in any manner. We are saying
You purchased 1 flat.
we did not purchase, my lords. He is a relative.
Oh.
We financed.
Okay, your finance.
We are not saying that we have
How much is
financed.
the money?
1.18 principal.
1.30 was the principal, out of which some they have given, so it's 1 point. But the point, my lords, is my lords will see.
Confine it to 2 flats.
My lords will see that as far as the High Court and the trial court is concerned, my lords will see they were given an opportunity.
05.
Page 70. My lords will see their conduct. And till now, they have not on their own given any security. My lords will see page 70.
Dismissed it without any.
High Court has
102 and 305 can be kept, Milos. Flat number 102 and 305.
To tell us this, actually, there should need not be any big contest in this. To the extent that you tell us, to the extent that you are,
Valuation has to be gone into, my lords. It cannot be really confined.
where is this property?
Milos is in Hyderabad. We have got some 90.
Where is it? Which area?
Secunderabad, it's 15 kilometers off Secunderabad, my lords.
Where?
Area, Lordship, I'll give the area, Milos.
My lords,
It's called Malkaganj, Alwal Circle, Kavanur village.
Or Malkajgiri?
Sorry, Milos.
Read properly.
Sir, Medichal
Medchal.
GHMC Alwal
Medchal,
Circle situated at Kavkur village, land in survey number so and so. 5 flats, 2 flats, Lordship said.
my lords, my lords, this should have been done. They did not, valuation was not produced. They did not make this offer in the trial court or
Because
the High
according to us, is 8, because Lordship will have paid D.
Square feet.
One flat is 1,500, 1,600, 1,100 and 1,500 square feet. I said minimum is 8,000 rupees per square feet. Minimum.
Valuation is 6,500 per square feet. This is a factual matter that has to be gone into only by the trial, at the trial court, my lords, they.
Because this is.
It's not done by them. They were given an opportunity to produce. They were given an opportunity to produce security, which they did not do at all.
Can I indicate what has happened?
You can go back to the High Court. will permit you to
Trial
file.
court, my lord,
Well-
we should go back to the trial court.
Doesn't matter wherever.
Because
they
your
want.
lordship said 2 flats, lordship may attach 2 flats. Well, this is
a
because a person is attachment before judgment. Somebody has attached all 5 flats on day 1. Can I just say, my lord?
He was given
16th October, first day trial court says furnish security in 72 hours, attach all 5 flats.
No.
This is, but can I show the order to your lordship, my lords? Just have an order at page 74. The manner in which the order is passed is lot to be said about this. Just have at page 74.
Before trial court.
Yes, ex parte order on day 1 saying that.
And what happens is that
He does not come back.
the entire business gets blocked.
No, so first you say you pay the money, then you attach my flat. So I can't pay the money. All 5 flats are
It is
attached.
the final direction of the.
Yes, Milo. So High Court has
This
this.
we will hear you. We'll hear you once.
The court also says.
Milo, can I just show page 74?
We'll just hear you, Lisbon.
Page 74.
Complete here. Page
74. This is the trial court order. I'm on the manner in which an order 38 order is passed. Lordship said 2 flats. Lordship may say 2 flats and close it. Or Lordship want me to go back to the trial court. I'm willing to go back with a valuation. No difficulty. But it can be closed with 2 flats is all I'm saying. Milo. Page 73, Lordship will have.
We are saying it's 2,500 per square feet. They are saying 8,000, my lords, without any document.
Page 73, Lordships have.
We will file this, my lords.
73, the first order, ex parte order.
Let him go back to the trial court or high court.
trial court.
So Lordship may then, because there are some, then these orders will remain, then I don't know how your Lordship want to word it.
Heard Mr. Gaurav Banerjee.
Doesn't make, doesn't make any difference. Name doesn't make any difference. She's Liz Matthew. Just to. If you get my name wrong, why can you?
Okay. Mr. Gaurav Agarwal, counsel on behalf of the petitioner. Paragraph, there seems to be a serious contest on the value of each of the flat.
Grateful.
Without considering, with due consideration of the actual value.
Milot.
The trial court has passed an order attaching all the 5 flats, before judgment.
Milot.
Okay. We are of the opinion that the petitioner can approach the trial court by filing an application along with necessary documentary proof indicative of the actual value of the flat. On that basis, the trial court,
He may also be permitted to.
yeah, the respondent is also entitled to file documents in opposition, if any, to the submission of the petitioner. The trial court will consider the evidence and pass orders to the extent that the plaintiff is to be secured. Is to be secured for the claim in the plaintiff. With this observation, the special petition.
We'll make the application in 2 weeks. Can we make the application in 2 weeks? Trial can decide it as soon as possible because lying attached for last.
We will only say that if such an application is filed, trial court shall. Okay, we'll also that trial court shall dispose it off within. Again, expeditious, correct.
Grateful. Without being
It shall
influenced.
take up and dispose it off expeditiously.
Without being influenced by the High Court order, Milot. Obliged. Thank you. Obliged.
But please, your lordships, the matter which was the Dwarkanath Malats had appeared, Malats.
Influenced by the observations in the High Court.
Lord, in this matter, my lord, I request some time, my lord, to reframe the questions of law. My friend pointed out there are some mistakes, my lord. We realize there are some mistakes, my lord, and but the question of law survives. Kindly give me 4 weeks time, my lord, to.
Mr. Datta is appearing, he'll explain.
Which item?
61.
61.
Matters are pending.
They realize.
May I just mention, Lord? Sorry.
Yes, Mr. Datta.
No, actually, what happened was
that is out of the back.
when the SLP was filed, they raised questions which did not even arise from the assessing officer. Also, they had copy pasted some other question by mistake and put in the SLP. When I filed my response to that, now they want to file a new additional grounds now. Now, Lord, the short point is this: that actually nothing survives in this matter.
Yeah, 7 years contract.
Sorry, Lord.
Matters are pending also, Malats.
There's nothing
Yes,
pending.
there's a
What
pending.
There are about 15 appeals, my lord, arising from the impugned order, my lord, that might have caused the confusion.
No.
My lord,
I'll tell you Lordship.
my lord, unlike there is associates councils, my lord, that is the
If I can
problem.
argue,
Sorry.
permit me to argue. But here what happened was, in a reinsurance, but Indian companies, when they take insurance, they get reinsurance. That is, they insure their risk. Whenever there's a foreign insurance company, part of the premium.
Yes.
When there's a reinsurance, suppose they insure, let's say, a large aircraft for 400 crores, the insurance companies take a reinsurance. Some of the reinsurance are by foreign companies, some by Indian companies, because they insure the risk. Now, the short point is, when I suppose I make 10 lakh rupees as premium and I have to pay 30% to the, say, Swiss insurance company, is that 30% taxable in India or not? High Court has relied upon a treaty provision which says for reinsurance premium, it will be taxed only in the country of that insurance company. So Indian premium is taxed here, Swiss premium is taxed there. So High Court realized it's a pure question of fact. They follow the treaty and they dismiss the case. That's the only case in this. He can file whatever he wants. So
No, I want to file that question of law only, my lord. Whatever questions are raised, do not arise, that I understood.
What is that?
There is no, I am not denying the fact, my lord, my friend is right. I only request 4 weeks time to reframe the questions of law, that's all.
Well, sir, relied upon judgment is pending before my lord's.
No. Sir, Arjit.
That I don't think it's.
I don't want to come in his way, but my friend can take instructions. If it's covered by a treaty, they did not file it.
No, that also I'll take care, my lord. Your lordship may kindly put off by 4 weeks, I will do the needful.
Not necessary, leave it at that.
Most of it.
62, dismissed.
Item 62 has become infructuous because High Court has dismissed.
Correct, dismissed as infructuous.
Grateful.
My lords, I appear for NMC in 63 and 63.1, my lords. My lords, what they are seeking is an additional round of counseling. This does not fall in the domain of NMC at all. In fact, MCC is the one who does the counseling, my lords.
I'm not asking for a direction against NMC. My lord, what happened was, because of my lord, the entire
Session started in December 2025.
That's correct. My lord, just two facts.
This is the one we should notice. What do you say?
Lord, Karnataka, my learned friend may just bear with me for a minute. Lord, the Karnataka High Court, my lord, passes an order on 25th February, directing that the admissions by conducting one more round should be completed before 18th March. MMC, NMC have no problem, my lord. They have conducted that counseling till 18th March. Lord, within this particular time, before 18th March, I go, my lord, with a similar request before the High Court of Telangana, 2nd March 2026. Lord, Telangana High Court, my lord, mistakes that your lordships are seized of the matter. Your lordships are seized of reduction of percentile. 10th March.
Adjourn the matter.
Yes, 10th March is adjourned. My lord, now, what is important also is, my lord, 12th March 26. Bombay High Court, my lord, in a separate case, which is, my lord, in the connected matter, passes an order directing, my lord, one more round of counseling to be completed. The state authorities have acted upon it. They have done one more round of counseling. NMC has not appealed. So today, my lord, all that we are saying is...
We are talking about 25, 26, 26, 27.
26, 27. My lord, all of these are 26, 27. And your lordships were pleased to extend it till 28th, my lord, February at the instance.
My lord, 25.
We'll ask her. That's why we called her.
25.
Yes, what do you say?
My lords, actually, the union can reply.
For whom?
Yes, my lords. I'm for NMC, my lords.
We are asking you.
Yes, my lords. My lords, this domain.
What do you say that your Bombay has gone and granted till 18th
My lords,
March?
that is in contravention to PGMER. In fact, NMC is in the process of appealing before this honorable court, my lords.
They are appealing against them.
Admissions are already
My lords,
completed.
those are in those Bombay.
Both those orders you are appealing, is it?
Please, my lords.
Even the Bombay High Court 12th March?
Yes, they are in the process, my lords. Vedanta, that is what they're relying on, and the judgment that they refer, my learned friend referred to, my lords, that is with.
Have you filed?
Please, my lords.
Have you filed?
Not yet, my lords. In the next 2 days, it will be filed because that is in contravention, my lords.
Counseling completed, students join.
Have you
My lords,
filed against
their
that?
institutional counseling has been
Students
permitted.
joined?
No, my lords.
Yes,
Students have not.
students have joined, my lord.
My lords, that I'll have to check whether students have joined in pursuance of 12th March order or not, but that is under challenge, my lords. As we speak, my lords, 3 rounds of counseling have been done. Mop-up round, my lords, may only see just one.
So Sharma, what's to be done?
I'll just go through the documents.
Just 2 submissions. My lord, just 2 submissions.
We understand we are trying to do something if you can.
5 rounds of counseling has already been over.
Never ending. But then that is one side of it. No, Mr. Sharma, on the one side, 5, 6, 7, 8 rounds get over. On the other hand, 377 seats are lying vacant. How do we do? How do we do? So most of those 377 relate to subjects which are not sought after. We know that.
And what happens when the counseling is going on?
So hey, when there are still people who are wanting.
Have it tomorrow. I'll go to the document.
Come tomorrow.
Tomorrow.
Let him in.
Tomorrow is.
There are no. We'll see what best can be done. Come tomorrow.
Everybody
Find out in the meanwhile what is the stand taken by with respect to Karnataka and Bombay.
Well, it's Karnataka, they pertain to.
Many things.
Well, I will find out. We will find out. We will
Tomorrow,
come
tomorrow.
back to But Karnataka pertains to OBC, some benefit not being granted to certain candidates. That has nothing to do
We
with
get
it.
pulled from two sides, seats go wasted. There are students who.
We have a Supreme Court judgment, my lords, where your lordship must be aware.
are only
It's
Supreme
my duty to bring out to your lordship's knowledge where the Supreme Court has said
No,
this
they-
cannot be a never-ending.
Have a look in it, advisors.
Great.
Your Lordship, I appear for the petitioner. It's an order of remand because. So first kindly see page 34. The first obvious mistake committed by the court.